Supplementary list, item number 1.
How many days delay?
52 days.
How many?
52. 52.
We'll issue notice. This case number 4, 2023. It's an application for consideration of delay of 53 days. Where is it written?
52 days, my lord.
52 days and preferring the instant appeal stuff. At paragraph issue notice returnable in 4 weeks. Yes.
52 or 51 days.
51 might be.
Which note says 51? That is 51 days.
This one is 52 days. Yeah, no.
My lord, one was withdrawn, my lord. Miss case number 4, you lords, you kindly take some.
Okay. Okay, so yes, 52 days. You should notice returnable also. Steps were taken by Eli within 1 week case.
Daily list, item number 1.
Near to the Panti.
My lord, my instructions post Lumslong, my lord. No works have been carried out, my lord. It seems that the roads are in a very bad condition, my lord. The transportation of my lord, the vehicle also, it's being very difficult, lordship.
Have you put something on affidavit?
I've just been informed.
How will we take cognizance of that? You want hard facts if they are to reply.
Absolutely, lordship.
My lord, may I on the contrary?
Let him finish.
In that case, my lord, may kindly permit me to file one affidavit, bring on all those records.
Of course, we'll allow you. But the thing is that has to be on substantive material, yes.
My lord, I have got a latest status report to my lord. It is dated 11/12/22, where the National Highway is carrying out all the repair works, my lord, and we have prepared a small.
Let us see also.
Yes, my lord.
In fact, my lord, this Clariat and Joy bypass, most of the area they have covered. They have done it, my lord. Post Lumslong, my lord, the work has not been carried out.
One more unfortunate thing is, my lord, the toll naka has been closed down by the local NGOs and the public, my lord. And on the one hand, they want the road to be repaired, and which is
why is it closed down?
by the antisocial elements,
Why?
my lord. The deputy commissioner, when our officers they sought help, also deputy commissioners is also saying we have no authority to deal with the public. You have to first get the road.
Who's representing NHI here?
I am representing the NHI, my lord.
Have you stated that? You have
No,
to
my
give-
lord.
you
This
give
is
notice of the
this is
court, then you
verbal
have to
instruction
give-
because
that also
we
you
are
have to
preparing
give-
our status report on the construction, my lord. But the fact on the ground remains is that, my lord.
You put it on affidavit. We'll take
Yes, we'll
cognizance
put
of
it
that.
in affidavit, my lord. And I believe the petitioner is aware of that also, that the toll naka is not being allowed, and it is
Not,
causing great
petitioner, my
loss
lord,
to the
general
exchequer, my
public. Why the reason why, my lord, times and again, my lord, they went to the office of the deputy commissioner for, my lord, repairing the roads. It was not done. So NHA, my lord, in spite of the fact that, my lord, the public they are suffering, they have been, my lord, collecting the tolls. Maybe out of frustration, my lord, it must have been carried out. In fact, my lord, I'll take the proper instructions in this regard also.
I hope you're not instrumental in what is happening in stopping the collection of toll.
No, my lord. No. In fact,
directly or indirectly, they are.
No, absolutely not, my lord. It had come somewhere in the somewhere I have seen in the, my lord, the clips some
Oh, it's secondary information.
second information.
And when the officials of the toll naka of the National Highway tries to impose, my lord, the people are behaving in such a way that government is also unable to give any protection to the.
How can it be? Rule of law has to be maintained.
That is what, my lord, very unfortunate, my lord. Operation. My lord, will kindly come to para number 3, my lord.
Yes.
The status of major strengthening and
Yes, I'm looking
landslide.
at that right now.
From February onwards, my lord, major strengthening work will be carried out by the National Highway, my lord. Now the pothole repairs which is being done, because with little rain and heavy vehicle being plied, my lord, this again it's a continuous process which needs to be taken on a temporary basis, my lord.
In fact, my lord, the points which has been raised here, it was raised sometime, my lord, before the honourable teachers also. These points were raised. In fact, my lord, all these points, it was supposed to be, my lord, there was supposed to be a meeting held between the state and the NHI to thresh out these issues. I don't think so, my lord. They have walked out.
Thrashed it out.
They are supposed to sit together, my lord, have a meeting and resolve these issues.
See, SL Infra assigned on September 29.
If some kind of observation may fall, my lord, saying that the district administration should also, for the collection of toll naka, which is...
We cannot take cognizance something just made on the bar, similar to the bar. If the Advocate General made it, then maybe.
Yes, then we'll file on the next date. We'll file by way of an affidavit, my lord.
The Advocate General says in open court that yes, that can be taken affidavit, then that also can be taken off. But if, unless when it happened, how it happened, how long it's been stopped, those details you have to provide.
We'll provide by
The
next
gravity of the situation, you provide the details.
Lordship, so far state is concerned, Lordship will kindly have the order of 2011-2023.
20?
20th 11?
Yes.
And Lordship, as per the order, the Deputy
Report
Commissioner
of Deputy Commissioner.
had submitted the report on 16/11/2023 and the petitioner counsel had sought time.
No, the petitioner had taken time, said I'll do a physical verification and file some
And to
sort of
whether
affidavit.
any observation
But
on
now they have not done that.
observation on the independent report.
Yes.
In this regard, my lord, as I've been instructed, this Joy and Clear Road, my lord, it has been inspected. In fact, on Saturday, petitioner has gone further, Lumsdong towards the further areas. That part, my lord, we have not got the proper...
Mr. S. Panthi, another counsel today, praised that we be allowed some time to file a affidavit with regard to the status report filed by state government on 16/11/2023. Stop further, next paragraph. The NHI's respondent number?
It's there are newly implemented.
Are you made respondent formally or is just...
It is made formally.
Then just write NHAI, Mr. S. N. Gupta.
One.
Yes, Mr. S. N. Gupta on behalf of the National Highway Authority of India has also filed a status report dated 11th December 2023 indicating the repairs that are being undertaken in the stretch in question. That is Joy to Ratachara section. Joy to Ratachara section. Stop. The same is a copy of the same made over to the petitioner and the same is taken on board. Stop. The next para, the petitioner may file an affidavit to the said report to, yes, just on so and so. He'll come after vacation, no?
After the publish.
Supplementary list, hearing. Item number 2.
Yes, Major. Well, I pay for the petitioner.
Yes.
Lordship, in this case, well, may I just draw your Lordship's attention to a few orders that your Lordships have been pleased to pass in this matter already. Well, in fact, my Lord, your Lordships have accepted that, my Lord, this, my Lord, notifications or amendments, my Lord, as they stand, my Lord, cannot, my Lord, be given effect. My Lord, may I request your Lordships to kindly take up the order of 20th June 2023 once.
Mr. Sinha, if it would be more apt if we look at the last order, whereby some...
Yes.
Yes, If we can just see the order dated 15/11.
Yes, ma'am.
Yes, because it refers now the order dated 3rd October, where the court had allowed the petitioner to file objections, if any, to affidavit filed by the state respondents. Yes.
Well, so far as that is concerned, well, we have taken instructions in the matter. Well,
Yes.
in view of the state's in view of the affidavit on record, well, they have merely stated that they are going to take certain steps. So, well, we have been instructed that there is no need to file an affidavit
Okay.
to that affidavit, and we can proceed with the hearing of the matter, because your lordships have been directing from the 20th of June that amendments be made to the scheme, and that has not been carried out till that. So, if your lordships are pleased,
order the 20th of June.
yes, madam. 20th of June, may I request your lordships to kindly have a look at certain observations that are made at page 2,
Yeah.
paragraphs 2, at page 2. If your lordship will come towards the middle of the page,
Yes.
this is by itself. This sentence starting this by itself. This is what your lordships have been pleased to record. This by itself is against a fair process, since as owners of distilleries, the partners are in the same position as the petitioners herein, and as owners of bonded warehouses, the partners become clients also of the central bonded warehouse. In the supplementary affidavit filed by the petitioners, it is indicated that though the government has fixed an ex-bond rate and the extent of commission to be passed on to the bonded warehouses, variable rates had been sought to be charged or threatened to be charged by the central bonded warehouse from different manufacturers. This, according to the petitioners, would be completely against there being a level playing field, since the higher rates charged from certain manufacturers and the lower rates charged from certain other manufacturers will have an impact on the quantum of supply and the products that ultimately reach the retailer's shelves. In addition, the petitioners claim that there are certain incentives which are selectively offered by the CBW or proposed to be offered that may further distort the price mechanism. At the same time, the petitioners point out that it is the considered stand of the state that it will not interfere in the pricing, as that should be determined by the market forces. The essence of the petitioner's contention is that if different sets of rules are applied to different suppliers of liquor to the CBW is in a monopolistic position to control the quantum of supplies obtained, and even though CBW may ensure that it takes supplies from every manufacturer, yet the quantum of the supplies would be dependent on the extent of income or profit that the CBW is able to glean from the relevant transactions. Then, kindly skip over the next paragraph and have a look at paragraph 6. This is your lordship's observations. Prima facie, an element of prejudice is made out, justifying the institution of the present proceedings. At the end of the day, it is for the state to ensure that rules are in place that do not allow a solitary entity that has replaced a group of entities to indulge in monopolistic practices or dictate terms to the manufacturers or distillers, or be in a position to decide which product and of what amount would land on the retailer's shelves. The state should know better and should bring in rules that will allow the demand at the level of the individual buyers to direct the supply of the product, rather than a state-appointed entity taking into account its profit-making exercise for deciding the same. And then, this is your lordship's direction. Since the CBW seeks time to ascertain whether it is charging differently from different manufacturers and distillers, or is making certain rebates and concessions selectively available to some manufacturers and distillers, let the matter stand over for 3 weeks. The state will do well to address the several issues indicated herein to ensure that there is a level playing field and that the manufacturers and distillers are not discriminated against or favored by the CBW. Then, the next order, if your lordships kindly have a look at 18th July 2023. This is what your lordships are pleased to record. Pursuant to direction contained in the penultimate paragraph of the immediate previous order of 20th June 2023, it is submitted on behalf of the Central Bonded Warehouse that it is not necessarily charging differently from different manufacturers or distillers, but due to the cost of transportation being reduced, the benefit may be passed on by certain manufacturers or distillers to the CBW. Implicit in such submission, this is very important, implicit in such submission is that there is an element of possible differential treatment arising out of the differential margin for the CBW. All that the court is concerned about is that similarly placed persons should not be treated dissimilarly by the CBW, as that would result in monopolistic practices and certain other manufacturers and distillers losing out. Well, I will not trouble your lordship with the rest of the order. Kindly have a look at the next order, 29th August 2023.
Yes.
It does not appear to this court that the state is serious in allaying the apprehension of the petitioners or attending to the several anomalies that have been indicated in the recent orders passed in the matter. Though the state was required to positively address the issues and come up with a modified scheme or suggestions that would bring about a level playing field, the state seeks further time. It is imperative that the state's modified scheme, your Lordship will kindly make a note of this, that the state's modified scheme is finalized and produced within the next 10 days. It is made clear that as long as the state can demonstrate that the creation of a centralized agency does not enable such agency to differentially treat manufacturers, whether by conferring benefits or otherwise, the apprehension expressed would have been taken care of. Then, my lord, the last order, my lord, which is relevant for our purposes, 19 September 2023. By the previous order of 29th August 2023, the court expressed apprehension that the state was not serious in allaying the misgivings of the petitioners or attend the several anomalies that had been indicated in the matter pertaining to the setting up of a centralized warehouse for distribution and sale of foreign liquor in the state. The previous order required modifications. Well, again, kindly note, your lordships are very clear that the previous order required the modifications to the existing scheme or a revised scheme to be presented by way of an affidavit when the matter appeared next. An affidavit has been filed today, though a copy thereof has been made to the petitioners only this morning. The state refers to the second paragraph of the affidavit to demonstrate that some tweaking in the existing scheme has been made. However, the petitioners, without having the benefit of studying the affidavit in great detail, submit that it is a merely cosmetic change that is suggested in how the central bonded warehouse functions. Then, the matter was adjourned, and after that, no further orders were passed. But, what is very important is that your lordships were, clearly of the opinion that, there is, differential treatment that the existing scheme meets out to, different manufacturers.
Now, only one thing is that, we have seen, because this, I'm not really familiar with the orders passed because I was not on the bench, but if you take us through the orders now, the only thing is that, why do you say affidavit is not necessary to the, to para 2 of the notification, where the notification has been issued, or whatever? Because if you say they say that technical committee has been appointed to examine extent reasonable commission of profit margin, what is the recommendations, and whether you are in difference to it. I mean, that is the only thing we have to know.
Well, there is. If your lordship will kindly take up the affidavit that has been filed the last affidavit.
Because,
may I just show your lordship what it says?
Yes.
Your lordships have formed the opinion that the scheme, has to be revised, or
it has to be modified. That's what they said. Yes.
That's right, my lord. I do not want to join issue. My lord, now kindly see, my lord, paragraph 2 of the affidavit.
19 September.
19 September.
Yes.
Yes, my lord. It says, paragraph 2, to ensure that no brand is treated differentially, the state has agreed to fix a margin of profit and to arrive at a reasonable percentage. The state has, by notification dated such and such, constituted a technical committee to examine the extent of fixing a reasonable or commission or profit margin at the manufacturers and CBW level for all brands within the existing structure. The committee has been directed to submit its report. Now, my lord, so far as the report is concerned, we don't have the report.
But the report has not been filed before the court. Mr. Khan, what's happened to the report?
No, sure. The matter
then why?
The report has been filed to the government is considering.
Why?
May I submit, submit in this matter?
Yes, Mr. Arvind.
Yes, Your Lordship.
What does the report say?
Yes, Your Lordship. I will place that report also. Report is under consideration. If I summarize or crux of the case of the petitioner is
No, we understand. The crux of the case is that, see, the court has found that there is some disparity. I mean, it's not all good. I mean, the way that the thing has been carried out. And the court has directed for certain modifications. Now you say technical committee has been appointed to look to it and the report has been generated. So where is the report?
No, Your Lordship, as on today, my lord, the issue is being examined by the government. One. Second, my lord, is that what my friend has argued, my lord, that central bonded warehouse has created monopoly and they are having difficulties in dealing with the monopoly, my lord. Now, what we are considering the entire issue we have taken note of the grievances of the petitioner, my lord, and we are trying to address the entire issue. Even we can have another CBW or central bonded warehouse also. That is also under contemplation, my lord, because whatever grievances which have been raised, my lord, if I can place one judgment of Supreme Court, because
I am only judgments right now. We only at the stage. See, Mr. Arvind, we only at the stage. there has to be
No,
some.
my lord, I can argue the matter on merits
Please,
if my learned friend
one
wants.
second, please, 1 second. Just listen, just listen,
Yes,
Mr. Advocate General. The thing is
Yes.
that, see,
Yes,
there's a
sir.
certain, there's a thread in the orders of the court, or orders of this court,
No,
correct?
yes, sir.
Now,
Yes,
the
that is
thread,
what I'm trying to
of the orders are that, like, there has been, it's been noticed that there's some, infirmity
Yes, sir.
maybe in the, and you've been directed to modify the scheme. Now you said that it's been put for technical committee. Now you see that has to come to a logical conclusion. Not that we truncated
Yes,
at this
sir.
point, then you place a good judgment that, it'll divert the whole issue.
No,
But
no,
we have to
I'm not,
proceed.
I'm not,
Yes. Yes.
I'm not at all on that. Lord.
Right.
The point which I am trying to make is that petitioner has filed identical petition in Haryana, Milord, where there also monopoly was created by CBW. The matter traveled to Supreme Court, and the issues which are being raised by the petitioner were addressed by Justice Joseph in his separate judgment, Milord. So that is one aspect of the matter. We will deal with that.
Okay.
Now, the grievance of the petitioner before your lordship is that this monopoly is creating some sort of distortion, and certain grievances have been ventilated time to time before your lordship, and those have been taken note. We are examining the entire issue in totality, Milord. It's not that only price differential. Now the question, Milord, is what is happening, because I am privy to certain deliberations of the committee. What is happening now, because the central bonded warehouse is saying that I am giving higher commission to fast moving goods which are fast moving. So whether they are entitled to give higher commission to goods which are fast moving, I am giving less. If there are goods which are of high value, I am giving less margin, because all those issues are governed by market forces. It's not that I can generate a report today saying that I will give you 5% commission on all products. That can't be, Milord, because product wise, issue wise, sale wise, there are so many complications which are there. Therefore, Milord, what I am praying, Milord, if there are certain observations are made by this court, possibly before the next date of hearing, we'll have a comprehensive report or comprehensive stand of the government, whether this the CPWD is a...
No, one thing, yes, Mr. Advocate General, there's no timeline for the technical committee to come to findings.
6 weeks.
Because if I can just, that's why I wanted to show certain paragraph, because identical grievance, that is nothing.
No,
One
we
paragraph.
don't want to go to Simcotisation. See,
No, because
we will
the
take the
identical
case.
issue was raised, Lord.
Well, may I make one very
Identical-
humble submission?
Identical issue was raised.
My learned
And
friend
identical-
advised the court that, my lord, it may not be, my lord, possible to apply uniform, my lord, commissions or, my lord, uniform, my lord,
Yes,
principles
so is true.
to all. No, my lord, he has admitted this, and this about, my lord, just to address your lordship on merit, kindly fix the matter for my hearing on merits at any convenient date. At an
Right,
early
we'll
date.
fix it
I
for
don't
hearing
think
then.
we need to-
Meanwhile, you file a technical committee report.
Yes, Lordship, we will do that. We'll do that.
Yes, after the last order. Stop. Let's start. Mr. Jason, on behalf of the petitioners, has submitted that no effort be necessary at this stage, in as much as the technical committee report, which has been referred to at para 2 of the affidavit of the state, has not yet been furnished or filed before the court. Stop. Next time, Mr. A. Kumaran, Advocate General, submits that the entire matter is still under consideration and prays that we be allowed to bring the same record and that the entire matter be heard thereafter. Stop. In consideration of submissions thereof, list this matter for hearing. You give a date just after the vacations, on so and so.
Well, kindly, my lord, indicates a convenient date. We'll, my lord, make it convenient to be before
Right.
the lordships.
When on? The first week of February.
Lordship, we have the second week of February, Milord. Second week of February will be...
Okay, second week of February. Yes, but that time we'll finish off the matter.
Yes, sir. On merit, I would
Because
like
see,
to
there's a
address
thread. There's a thread in the entire. All the orders is a thread, and so they have to. We have
One,
to bring a
my lord, very
logical
humble
conclusion.
request, my lord, kindly direct that, my lord, the report must be filed suitably in advance before, my lord, the
Yes, sir.
date
It
fixed for
is
hearing,
further.
so that
It's
we can
further.
finish the matter.
It is further indicated that it is expected that the report should be filed well in advance before the next date of hearing. Yes. And copy thereof supplied to the concerned parties appearing today. Yes. Right.
Good.
Any mention?
Muhammad Tayyab.
Lordship, yes, Lordship. Lordship, so Senior Counsel also, he's on sanction leave today. And he requested me for the item number.
His case is staring the court in the face. Mr. Qureshi,
On the next date, we'll conclude, finish it, Lordship, this case.
Only simple matter, whether entitled to get the salary or not.
Not your case, not your case.
Of another case.
21 to 26.
After vacations, yes.
Lordship, there is one more matters with the...
After vacations on the prayer of the counsel for the appellant, as the matter is still yet to be resolved. It is noted herein that on the next date no further adjournments will be granted.
Yeah, we'll finish it because there is a old pending matter.
It is further noted that it is expected on the next date no further adjournments will be sought for. Yes, and?
Lordship, item number 28. 28, what happened in this case during the course of hearing? Lordship has allowed this private respondent to file an affidavit. He filed an affidavit. He has obtained some information under the RTI. He filed an affidavit showing that he is a sanctioned teacher. Then I also filed an application for clarification. I also got some clarification from the department and found that he has misled the department. So
correct, Mr. Pandit, then you'll be in trouble.
So I got the letter from the department, 2 letters, which I want to place on records.
Yes, Mr. M. Qureshi, counsel appellant submits that due to the receipt of certain vital information that has a bearing on the matter, he prays that he will allowed to bring the same by record by affidavit. Prayer is allowed. Yes, just after 2 weeks. Yes.
Much obliged.
May I please, Your Lordship, I beg to mention item number 33, Lordship. 33, Lordship. That is after vacation, Lordship.
Okay. After vacations on the prayer.
May I please, Your Lordship, I'd like to mention item number 47, Your Lordship.
47?
Yes. The conducted counsel is out of station, Your Lordship.
Bapalla Shisha. Who's the conducted counsel? Mr. Varjari?
Yes, Lordship.
Yes, and the prayers also after vacation.
Right, Lordship.
After the petitioner.
May I please, Your Lordship, I beg to mention item number 38, Your Lordship. Let the matter come after vacation, Your Lordship.
28?
38, 38.
Yes, 38 after vacation.
Much obliged.
May I please, Lordship, I beg to mention item number 44, Your Lordship. Let this matter be taken after our vacation.
If any hearings can be urgent matters only, yes, after vacation, yes. Because this court won't be here tomorrow, yes.
May I please, Your Lordship. Lordship, I beg to mention item number 34.
Number?
34.
34. He has objection, I think.
Lordship, Lordship, sorry, stated that Lordship
Yes?
wanted to take this matter up today, Lordship.
34.
Lordship.
It was at their request.
At the request?
Yes, no, Lordship, at the last date, the petitioner had requested for a second round of inquiry, but the Lordship has found that the petitioner doesn't have any
Yes, Mr. Hassan.
right out here.
Why is seeking time?
My Lord, I'm not fully ready, my Lord, actually, my Lord. We are seeking for second round, second inquiry, my Lord. So, my Lord, kindly after vacation, my Lord, we'll do hearing.
No urgency in the part of respondents.
Lordship, she's already out from service, Lordship. So
Yes, my Lord.
Out of vacation.
My Lord.
34 and 35.
34 and 35, my Lord, connected.
34, 33. Oh, no, 35. 35.
Yes, ma'am.
Much obliged, Lordship.
I'll be obliged.
Please, Your Lordship, I beg to mention item number 1 and 2 of the main list, Your Lordship.
1 and 2?
1 and 2, Your Lordship.
Of the?
Main list, yeah.
Main list 1 and 2 is motion.
It's for admission hearing, Your Lordship. Admission hearing.
Mention when it comes up. Don't mention it when it's...
My Lord, I beg to mention item number 37, my Lord, on behalf of PR Paske, my Lord.
37.
Yes, Your Lordship. Lordship, we pray this matter be listed after the vacations, my Lord. Due to personal difficulty, is unavailable today, Your Lordship.
No objection.
Okay. Yes, 37. That's a miss case.
My Lord.
Yes. Yes. Yes.
Obliged, my Lord.
Please, Your Lordship, I beg to mention item number 36. Will it come off to...
Who's the pin at the side?
Sir.
Mr. Nombri. No objection? You are there also?
Yes.
Notifications on the prayer of the Council for the Appellant. Yes, that's it.
Obliged.
Please, Lordship. Lordship, I beg to mention item 30, Lordship.
30?
Yes, Lordship. But can you have this matter after vacation, Lordship?
Yeah, 30.
Obliged, Lordship.
That's it.
Supplementary list, item number 1.
May I please, Your Lordship?
How many times you are going to run into court?
My Lord, this is
very
the
familiar case.
This is the fourth round, my Lord. But
what is your grievance now?
My Lord, all this time we have been asking for conduct of the fresh election to the post of Sardar, my Lord, under the Sirdar Nonglang Sirdarship. Now the incumbent, who is holding, we are saying that he has lost the confidence of the people, and in fact there is a report by the Sirdar himself saying that he is not fit to hold the post of the Sardar. And also there was an occasion when his appointment was terminated, he was removed. Then by an order, he still claims himself to be the Sardar, which is in subordination to the Sirdar, my Lord. So these are some of the grounds
Very confusing. What is your prayer here?
So, my Lord, here the prayer here is like simply we are asking for a directions either to the KHDC because political appeal is pending there, or to the Sardar or to the Sirdar of Nonglang Sirdarship, because four petitions after we have withdrawn from here with a liberty to approach alternative remedy. 4 petitions are pending before the Sirdar. He is sitting over the petitions. Ultimately, having no choice, we had to go to the district council. District council says that, sorry, we have already passed an order, we cannot recall our order. Political appeal number 4 was dismissed at that relevant point of time, not on merit, on technical ground, saying that we have come under the wrong provisions. So, my Lord, that's so. Just very briefly, my Lord.
No. What do you want now?
No, my Lord, we want our representation.
Relief.
Our representation should be disposed of, my Lord.
What representation? Where is it?
Four representations are pending before the Sirdar.
I'm looking at the prayer right now.
My Lord.
Again, sir, for dismissing the political appeal or hearing the petitioner. Which political appeal is this?
Political appeal, my Lord, that is the last political appeal that we have filed, my Lord. That is at page 189, my Lord. Page 189.
Okay.
So this political appeal...
Because you appeal against inaction of Sardar.
Yes, inaction of the Sirdar. And this political appeal was dismissed without hearing us by simply saying, by order dated 13th November 2013, page 201, by four line order, saying that.
Now they're saying that because it's already been taken up before 27 April 2022.
Yes.
Why?
Yes. That 27 April 2022, my Lord, that was dismissed on technical ground, saying that we have come under a wrong provision. And after that, against that, we came before this honorable court. And while pending, we said that, okay, we will go to the Sirdar first, we'll go on appeal, will alternative remedy under the rules. We have filed 4 petitions, at least 4 petitions.
I think there's a misdirection. Originally,
they should have raised the issue before the Sardar.
No, now
so far
they came back, they went there,
Yes.
he didn't do anything, so they filed appeal for directions to the council to direct the Sardar to dispose of whatever grievances they had.
originally there was an appeal. There was something wrong with the appeal, defective.
Okay,
We have disposed of.
Then
They came here.
Don't take recourse at appeal. If it is for technicality, nothing's been decided in that appeal. Now they have gone again to the Sardar to air the grievances. He's not passed any orders. Then they came on a political appeal. If what I'm seeing is correct, which has been dismissed by you saying that you already addressed the issue earlier on when nothing was decided earlier on the earlier occasion.
We were under the impression that they will seek some alternative remedy before the Sardar. And so far the appeal is concerned, we are bound by some earlier decision where we cannot review our own decision.
Fresh appeal.
If we file fresh appeal, then fine. But
They already filed a fresh appeal.
there was no liberty granted by this court.
See, court said go take alternate remedy.
Yes,
They went
yes.
to Sardar to air the grievances. Nothing was done. Then they came to you and you said not. You haven't done anything. Also dismissed the appeal.
I have a suggestion, Your Lordship, that if this honourable court permits, without hearing the respondents, can direct the KHDC to hear the matter on merit.
To examine the political appeal again.
Yes, my lord.
The grievance of the petitioner in the presented in the petition is that is that the respondent number 2 is a committee without hearing the political appeal number.
Political appeal number, the last one is what was saying. Yes,
201.
this is not been political appeal. My lord, unfortunately, they have not given us a political number also.
To give the petition in short is that the respondent number 2, executive committee, respondent number 2, executive committee's council, has dismissed a public appeal without hearing the petitioner on the ground that the matter had earlier been disposed of on 27 April 2022. Stop. It has been submitted that this matter was brought before this court on an earlier occasion by way of the WPC number.
WPC number, my lord.
Which number?
Just 321, my lord.
By number 321?
321 of 2023, my lord.
2023, but which is withdrawn.
I'm sorry, 2022, my lord.
22, but which, however, was withdrawn with liberty to seek alternate remedy. Stop. It appears that thereafter the writ petitioner had preferred the petition before the Sardar of Nonglang was been arrayed as respondent number 5.
No, 5 is the
number 4.
3.
Number 4.
3.
Number 3 and 4.
3 and 4.
For appropriate decisions with regard to what is the dispute you had against appointment of the Sardar?
Yes, my lord. Sordar, S-O-R. Sordar.
One of the Sardar of which village?
Sordar. Of the village. Of the village Tingyang.
Of Tingyang village. As the said petitions were not looked into by the respondent number 3 and 4, the petitioners it is submitted had preferred the appeal before the district council, which however was summarily dismissed without entering the merits or deciding the claims. Next, at this juncture, it has been prayed by the council petitioner that it would suffice if the political appeal is revived and the matter begin due consideration by respondent number 2, as the subject matter and issue is very limited. Stop. Next, Paramiji V. Chikintas, letter special counsel on behalf of respondent number 2, his usual frankness has acceded to the request and submits that it would be fair for the end of justice if the political appeal would be examined by the respondent number 2 in accordance with law. Stop. Accordingly, this writ petition is disposed of for the direction that the respondent number 2 shall take up the matter relating to political appeal of the writ petitioner versus this Ming Roy Paryong and another for fresh consideration. The earlier order dated 13 November 2023 dismissing the separate appeal is set aside.
Item number 2.
Yes. What is this?
Your Lordship, this is an application under 226 of the Constitution to direct the respondent authorities, Your Lordship, to recall and rescind the sanction accorded to the respondent number 5, who's
regarding?
This is regarding the pensionary benefits, Your Lordship. Respondent number 5 is the second.
Issue notice, respondent number 5.
I'll be accepting notice for respondents number 1 to 3, Lordship.
Heard Mr. L. Tingo on account of the petitioner. The issue notice. MSNG Shilasena, some senior advocate, is present. Accept notice on behalf of. This is 1, 2, 3. Steps to be taken for issues of notice to 4 and 5 within 3 days. Is that after 3 weeks? Yes.
Much obliged, Lordship.
Yes.
Item number 3.
Thought it's supposed of without notice.
Please, Lordship. Lordship, kindly pass over for some time, Lordship.
Why?
Senior counsel is busy in other call, Lordship.
You asking any interim prayer?
Lordship, I suppose there is, Lordship.
There is? What do you mean suppose there is? You have not looked at the matter? What's the matter about?
Lordship, I have not gone through the file, Lordship, since
Very
the file was with my senior Lordship. Lordship, he's coming, Lordship. If this matter can be taken up after some time, Lordship.
Yeah, after some time.
Obliged, Lordship.
Item number 4.
Could we?
Yes.
Lordship. Another board, Lordship. After some time, Lordship, this matter is solved.
Another board. You don't run away, Mr. Ganta. You have the habit of doing the disappearing act.
I finished my attendance.
Daily list item number 1.
Please, Your Lordship, I'm praying for some accommodation in this matter, as the senior conducting counsel is indisposed, Your Lordship.
I was informed yesterday, my Lord, that they are not taking up. There's an interim panel, it may be extended.
Yes. As the senior arguing counsel of the matter is indisposed, requests have been made for some accommodation. Stop accordingly. List is matter of vacations for an admission hearing. Next line, in the interim order passes, continue to the next date. Yes.
Obliged. 1 and 2 is connected, Your Lordship.
Item number 3.
Replied objections have been
filed? Objection they filed. I filed rejoinder. Everything is ready for argument. So I have an outstation lawyer. Lordship may please hear us.
Yes.
So, may I start?
Yes, please.
Okay. This is an application.
I can you. Arbitration Constitution Act. Arbitration Act 6, yes.
It's application under section 11(6) of the Arbitration and Conciliation 1996.
Yes.
Lordship may kindly see the section.
Yes.
Subsection 11, subsection 6 is relevant for us, Lordship. Lordship got it?
Yes.
Where the under an appointment procedure agreed upon by the parties, we are A only. A party fails to act as required under the procedure. So here, the procedure is I appointed the arbitrator and I demanded an appointment of arbitrator from their side. They did not appoint, and therefore, then what will happen? A party may, in the end, after C, B and C are not relevant. So a party may request the Supreme Court, or as the case may be the High Court, or any person or institution designated by such court to take the necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. So we are only, 6A is also relevant, but we are not at the moment. That we will come when the stage comes. that was introduced, then it was withdrawn also, but we are not much concerned with that. Now,
where are you reading? You are Mr.?
I am George Thomas. George Thomas.
Mr. Thomas, yes.
I read subsection 6 of 11. May I read again?
Yes. Yes, we are not appointed procedure agreeable parties. You said 6A. Party fails to act required.
6A is also relevant, but at the moment we are not concerned with that. I will come to that. The stage comes if it is required.
Right. Okay.
So now this petition is filed, and they filed a reply, and I filed a rejoinder. The pleadings are complete. Now, the relevant facts I have stated, but they have also stated the relevant facts. So I prefer to rely on their relevant facts. So that, may I read those relevant facts from their petition itself? Therefore, there will not be any controversy regarding that. That in their affidavit in opposition, Lordship may kindly see para 3 to 6. I may read that.
Para
3 to 6. In page number 2, it starts. May I start reading?
Yes.
That the brief facts of the matter are that a formal contract agreement dated 10/1/1996 for the construction of Rockfield Dam with the impervious core fill on the river Dayang for Dayang Hydroelectric Project Nagaland was entered into between the parties. During the course of the execution of the work, certain disputes arose between the parties, and the petition filed letter dated 12/3/2003 sought the reference of disputes claimed to the arbitration under arbitration clause, that is clause number 66 of the general conditions of the contract, and the disputes claim as raised by the petitioner were referred to the arbitral tribunal constituted in accordance with the arbitration clause, comprising of Justice Sarpal, retired as presiding arbitrator, Sri I.H. Hazariga, nominee arbitrator of NIPCO, and Sri J.K. Srivastava, nominee arbitrator of Bhagirath Engineering Limited. They are terming it as first reference. I will say there is only one reference, but I will come at the stage. They are, the respondent on 3/6/2005 also filed an application dated 16/5/2005 under section 16 of the Arbitration and Conciliation 1996, challenging the jurisdiction of the tribunal and maintainability of the claims for non-compliance of the mandatory prerequisite of the arbitration clause. The said application was heard at length, and the arbitral tribunal, by its order dated 29/5/2008, left the question of maintainability of non-compliance of prerequisite of clause 66 open to be decided at the time of passing the final award. The arbitral tribunal passed the award on the claims referred by the petitioner and published the award on 18/1/2020. But, however, the arbitral tribunal did not pass any final order on the application dated 16/5/2005 filed by the respondent. The tribunal awarded so on. So the question was, Lordship, I am posing for him.
Jurisdiction.
Pardon, Lordship?
The question of maintainability was not decided.
That was not decided by the tribunal. Fortunately, but I am not responsible for that decision. They did not decide in the award. That's all. The tribunal awarded total sum of so on. So then they are referring the claims. These claims, there is no dispute. I also, because I am agreeing with them. Now kindly come to part 4.
Yes.
All that is 4. Being agreed by the award dated 18/1/2020, both the parties filed applications under section 34 of the Act for setting aside the award dated 18/1/2020. That means both parties were disagreed with the award, so disappointed with the award, both filed apart. The application filed by the respondent corporation was registered and numbered as commercial arbitration case number 2 of 2020, and the application filed by the petition was numbered as commercial arbitration case number 3 of 2020. The pleadings were completed, and both the parties filed their objections rejoinders. That both the petitioners were heard at length, and the commercial court, by its order, judgment and order dated 28/6/2022, set aside the award dated 18/1/2020 on its. This is very wrong. On its merit. Kindly note here, it is not on its merits. I will satisfy. As agreed by the parties, the disputes claims were also referred to the Committee of Conciliation of Independent Experts. But since no final agreement for settlement of the claims could be arrived between the parties, the conciliation proceedings were dropped. So the conciliation was dropped subsequently. So that is after the setting aside of the award. It was given into conciliation. 6. That after the order dated 28/6/2022 was passed by the learned judge, Commercial Court, Shillong, the petitioner filed his letter dated 15/7/2022 sought second reference of the same disputes. There is only one reference, that's my submission, but I'll justify it. Claim which were the subject matter under the first reference before the learned arbiter tribunal constituted validly by the parties in accordance with the provisions contained under the clause 66 of the general conditions of contract. That means arbitration agreement admitted, contract admitted, disputes admitted. So now only thing is whether they have acted or when I issued notice or not. That's the only issue. All other things are...
Now your case is that now once the award has been set aside,
yes,
everything is taken afresh again.
Yes, absolutely.
That means that you made the application under Section 11.
Section 11, again.
5722, you filed.
That I will justify through judgments. So after the conciliation proceedings failed, the petition issued a second notice. So they again say, first notice, then we went to conciliation dropped, then again I issued second notice, because as a conciliation. So both are admitted. I am reading from their reply only, because it is not there dated. For appointment of arbitrator under clause 66 of the general conditions of contract for adjudication of the same disputes, claims which were the subject matter of the adjudication under the first reference. So they themselves say same disputes I am asking for before the arbitrator tribunal. The petition also appointed his nominee arbitrator by nominating Subhash Patel, retired secretary, government of Gujarat, and requested the respondent to appoint his nominee arbitrator. The respondent corporation, by letter dated, enclosed at page 100 of the instant petition, expressed its inability to agree with the second request, same disputes claimed to another tribunal on the ground that the second reference is not at all maintainable. But this objection I dealt in my petition. In the reply, they did not say anything on that part. Leave it for that part. Now, up to 6 only it is required. So, facts are admitted from both sides. Therefore, there is no, that is why I read their reply. Only thing is what they say is that the judgment or the order and judgment of the learned commercial court was on merits or not. That is the only issue they are raising. If it is raised on merits, then you cannot go for a subsequent reference. That is their case. I have to meet that argument. So, therefore, all the ingredients are admitted by them. In a section 11.6 petition, only 3 or 4 things are required to be seen. Number 1, whether there is an agreement, admitted. Number 2, whether there is an arbitration agreement, admitted. Number 3, disputes arose whether within the contract and referable to the arbitration agreement, admitted. I issued notice, admitted. So, my respectful submission, 11.6 is fully satisfied. Now only we have to see 1 or 2 objections raised by them. That now I say, first I refer to the only judgment which they are referred in their reply, that is DLF Home Developers Limited versus Rajapura Homes Private Limited.
Where is that referred?
They are referred in para 11. Para 11 of their reply, that is before Lordship. No, that their
judgment.
Judgment, what I will do, they are not given. What I may do one thing. I have got a compilation of judgments. If Lordship is pleased, I can. This judgment is also there. Kindly.
With regard to this case, a compilation.
Yes. Only this. I will give code.
Yes. This is versus Rajapura Homes.
Yes, they are referring. I am also referring to the same judgment. So now I am referring to para 11. I am referring to para 18 and 19. They are also referring to para 18 and 19. So let us read that. It is starting from first judgment, but the relevant portion is page 14.
Yes.
The same judgment, page 14. So, in page 14, let's have got page 14?
Yes.
So, I would read para 17 also. It is also, because when I said about 6A, that I said I will say later. There is no gainsaying that by virtue of the Arbitration and Conciliation Amendment Act 2015, by which section 11.6A was introduced, the earlier position of law as to the scope of interference by this court at the stage of referral has been substantially restricted. It is also no more res integra that despite the subsequent omission of section 11.6A by the Arbitration and 2019, that I am posing for a moment, this was omitted in 2019 Act. But still, judgment says the legislative intent behind thereto continues to be a guiding force for the courts while examining an application under Section 11 of the Act. 18. This 18 and 19 they are referring to. The jurisdiction of this court under Section 11 is primarily to find out whether there exists a written agreement between the parties for resolution of disputes through arbitration and whether the aggrieved party has made out a prima facie case, arbitration case. These are the two requirements I have demonstrated from their reply itself. These are
all are present.
All are present.
Right, okay.
The limited jurisdiction, however, does not denude this court of its judicial function to look beyond the bare existence of arbitration clause to cut that wood, dead wood. The meaning thereby that if some disputes are referred and prima facie your lordship is come to a conclusion, how can this dispute be referred to this arbitration agreement? Then the Honorable Court can interfere. But in their reply, they are referring to these disputes and it is covered under the arbitration agreement. So therefore, this application is not covered there. Now, a three-judge judgment in Vidya Dharolia has eloquently clarified that this court, with a view to prevent wastage of public and private resources, may conduct prima facie review at the stage of reference to weed out any frivolous or vexatious claims. So in our case, there is no such claims. Both parties say claims. In this context, the court, speaking through Sanjeev Khanna, Justice, held that scope of judicial review and jurisdiction of the court under Section 8 and 11 of the Arbitration Act is identical but extremely limited and restricted. I am pausing for a moment. Kindly wrote Section 8 and 11. Now, I am referring to, after this judgment, I am referring to a judgment of your lordship. Your lordship passed a judgment under Section 8. Even though that was dismissed, that is the second judgment I am referring to. Lordship's own judgment. Because in I think a hire purchase agreement, two agreements were there, whether that I will come, I will, but that judgment also under section, because why I am referring, 8 and 11 are similar, identical. The Supreme Court says.
Yes.
So, Act is identical but extremely limited and restricted. The general rule and principle in view of the legislative mandate clear from Act 3 of 2016, Act 33 of 2019, and the principle of severability and competence is that the arbiter tribunal is the preferred first authority to determine and decide the questions of non-arbitrability. The court has been conferred power of second look on aspects of non-arbitrability post the award in terms of, so that's a general scheme. First the arbitrator will decide, but whether his decision is correct or not, again this court will consider.
Thomas, if 1 second, sorry to interrupt, but the thing is that if we come to the core question now, the thing is that according to you, now this award was passed in 18 January 2020, correct?
Yes, Lord.
And due to that one
technical
was not decided, the entire award was set aside.
Yes.
It's not a question of where we are operating now. There's no question second reference according to you. According to you, now you made application under Section 11. You have nominated the arbitrator. All you have to do is nominate their arbitrator.
Absolutely.
That's the only thing you ask.
Absolutely.
Mr. General, why don't you nominate arbitrator? Why you want to go through all this rigmarole?
No. Because when the other side take an objection.
No, they objected, but then if all the ingredients are present and if there's been no,
actually, within 5 minutes.
The only thing that's argue whether res judicata will apply. Whether that setting aside award will amount to that award will be
yes. But
I understand correctly.
Absolutely correct. This issue can be decided within 5 minutes. But I thought, because when I come from outside, I thought I should take care of all the. Therefore, if Lordship may permit me, I will.
Because very limited jurisdiction we have.
Limited jurisdiction.
Is that now only I have to ask Mr. General, why not appointing arbitrator? That's all.
Okay.
Why not nominating?
Okay. So, otherwise, I reserve my right to make further submissions.
Of course, no. I mean, I understand you submit. I'm not cutting you short.
I am obliged.
I'm not cutting you short. I'm just saying that, that...
I am deeply obliged.
Yes.
Your Lordship.
Why are you objecting to the matter being up again?
Because
nominating arbitrator. Why?
Because Your Lordship, once the disputes are referred to the arbitration, under the arbitration clause and the contract agreements, and the arbitral tribunal is constituted, in accordance with the contract agreement, and disputes are decided by the arbitral tribunal. He has 7 claims. All the 7 claims on merits are decided.
Okay.
Decided. And thereafter, both the parties challenge the award under section 34. Under section 34, award is set aside.
Correct.
No, my point is this. Once the award is set aside, there is no question of adjudicating those dispute.
Claims again.
Again, under the same contract agreement, either by the same tribunal or by a different tribunal.
Why?
That's what I am coming, Your Lordship. The principle of res judicata would apply. First thing, Your Lordship, what my learned friend says.
General, just tell the court.
No, Your Lordship.
It's a totality.
Your Lordship, this requires.
If the matter, the award will set aside on technical issue, or whether
It's not.
or whether
Your Lordship, this is.
You see, just you try to make the court understand also. Was the award set aside in its totality?
Yes, in totality. Award is set aside in totality. No, Your Lordship, does it mean that if a party loses under section 34 or under section 37, they loses, and they will again go for another arbitration with respect to the same dispute. That is why I want to satisfy this honorable court that there is no such provision either in the arbitration agreement or under the Arbitration Act which allows the party to go for a second reference or
you mean
for
to say
constitution.
that all the claims have to be educated afresh.
Yes, see, Your Lordship, I have led the evidence so far that disputes are concerned, arguments are advanced.
One second. Now, from what I could understand is that there was an objection raised with regard to maintainability of the.
Yes, Your Lordship. Correct. That was raised. Your Lordship will come to. Your Lordship will come to my affidavit.
Okay.
Affidavit. In Annexure 1 is my objection petition, which I have filed before the arbitral tribunal, and raised the issue that there is a non-compliance of the arbitration clause. The contractor has not followed the arbitration clause.
Okay.
This petition, Your Lordship,
was never decided.
Was heard at length. It's not that the arbitrator has not dealt with this petition at all. They have dealt with these petitions and heard me on number of occasions. Both the parties were heard. And they passed a speaking order on 16/6/2018, that is page 39.
They passed an order?
They passed an order.
Let's see. 16?
16/6 an order is passed on 29/5/2008, which was communicated on white letter dated 16, page 39.
Yes.
Page 39. Your Lordship, it's a very all the contentions are noted by both the party. Then, Your Lordship, I will just take to page 49, paragraph 16.
Interesting case. Yes.
We have carefully examined the submission made by the learned counsel. These are examined. Then, Your Lordship, then come to page 18, paragraph 18. Yes. After examining the documents mentioned in the earlier paragraph, we, however, find that the white letter dated so-and-so. They are giving some observation here. What happens, Your Lordship, in the last portion, they say that to sum up, we hold that the preliminary objection raised on behalf of the respondent in this application cannot be adjudicated at this stage, as the evidence is yet to be led by the parties. Accordingly, we leave the issue raised in this application open.
So it was inconclusive.
Yeah, this remain inconclusive. There is something which there is a difference between saying that the arbitrator has not dealt with the application. They have dealt. He was given full opportunity. Evidence were let, and award was passed. Proceeding continued for 16 years. Award was passed after the hearing was concluded due to the illness of the presiding arbitrator. Award was passed after 3 years. Maybe it skipped from the mind of the tribunal. Tribunal thought that they have already passed the order, and therefore in the final award there was no mention about this. Now, under these circumstances,
that means it was on this consideration that commercial court set aside entire award.
No, not on this.
Then?
Not only on this, for others also. No, Your Lordship, if this is the position, what does the law say, Your Lordship? Arbitration. Your Lordship will just take Arbitration Act.
Yes. I think it will take some time.
It will take time. If Your Lordship, I can suggest one method, one proposal, which will cut short the things. Because this is a very pertinent question. Possibly we have here in this High Court we have not come across such a situation where the award is set aside, and again there is a request for referring the same dispute to the same arbitration. It cannot be taken so lightly, Your Lordship, because this will lay down the law. What I suggest to Your Lordship, if that whatever objections I have raised, either this court has got the power to come to give a finding. If this court finds that the issues raised in my objection petitions requires a detailed investigation of the facts, Your Lordship may leave the question, leave this issue open to be decided by the tribunal, and Your Lordship may give 15 days time to me. I will appoint my arbitrator. Matter ends there, because either Your Lordship will have to listen, will have to take care of these objections.
Because see, the objection on the 11.6.
And no, 11.6 power, Your Lordship, I will explain. Give me 2 5. What is the power under 11.6?
2 minutes, okay.
Your Lordship will first take section 11.6.
Yes.
Now, where under an appointment procedure agreed upon by the party, a party fails to act, and these are the things he has already read. Now, this 11.6 was amended by 2015 amendment, and 6A was added. Now, 2015 Amendment Act came into force with effect from 23/10/2015. So after 23/10/2015, so far the power under section 11.6 are concerned, they went under radical changes. Now, what changes were introduced, Your Lordship will find in the subhead down below. Subsection 6A, Your Lordship is holding which year's Arbitration Act?
23.
And that will be there. In column number 2, subsection 6A, it was added by 2015 amendment, and subsection 6A was omitted by Act 23, 2019. Earlier, subsection 6A was inserted by Act of 3016. Prior to omission by subsection 6A, stood as under the Supreme Court, or as the case may be, High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree, or order of any court confined to the examination of the existence of the arbitration agreement. 6A, Your Lordship, has curtailed the power of this court to a great extent. Under 6A, this court was only required to see whether there is a written agreement or there is no.
But the judgment Supreme Court
No,
says
yeah,
that's
just give me 1 minute time. This 6A was omitted. They found that no. 2019 omitted this. Though the very fact that this was omitted has given scope to this court. That is why the judgment which my learned friend also relied and I also relied, I will read it once again, Your Lordship.
After my learned friend, give me 5 minutes. I will satisfy Your Lordship so that everything will be over. Even my learned friend is also agreeing that he can appoint the arbitrator. That there ends the matter. But still, I can satisfy so that no doubt will be there.
He says appoint arbitrator, but with a rider. That that the thing is that the whole purpose of arbitration will be as it is. This one took 17 years to resolve, or 16 years. Again, we relegated to the arbitrator to decide on these points. They couldn't decide an earlier point and passing the final award.
That's why, Your Lordship. That's why.
One point. Now again, we again burden them with another point of reference.
No, I will.
They decide whether that was final or res judicata would apply. Then they'll be caught. It'll be like a vicious cycle.
Yes, Your Lordship. When this point is raised.
Yes.
When this point is raised.
Fine. Relegating to arbitrator, what will it decide? Again, whereas res judicata will apply.
No, Lordship, here under 11.6, I have a right to raise this point.
Of course, you have
I have a right to raise this point.
No, there's no one questioning your rights.
Yes.
But the only way is you find a viable via media where these disputes can be set to rest.
Yes, Lordship will just see the order of the district judge.
No, you say you want to see the judgment first?
No, Lordship, if I can.
You allow me.
I'm sorry.
Be sorry.
I'm sorry.
No, please. Else we'll adjourn it sine die. Yes. Yes, what do you want to show?
No, just a minute.
Because if we want to go into it, it'll take a long hearing, and as we are, 16 years.
Your Lordship,
16 years you waited. I don't think it'll harm you to wait another month.
It doesn't matter.
We'll adjourn it today, Mr. Thomas. We need the detail.
I may be permitted to say one thing.
Please.
Because when I started, I wanted to kill the argument of res judicata by showing Supreme Court judgments.
I have not yet opened.
Yes,
but he opened by saying that res judicata will apply. If I satisfy Your Lordship by Supreme Court judgments, res judicata will not apply. There ends the matter. Let my learned friend issue is res judicata.
At least let the court examine the matter in detail on its own accord.
That's what
I can at least see where the facts lie.
That's
because
why.
It's in motion stage.
If Lordship give me.
Admission stage, let the petition be admitted. Fixed for hearing.
Yes, admit the petition.
I have no problem.
Lordship may, because I started my argument. In the meantime, Lordship said, if this is the only issue, I will ask him what is his.
These are not the issue. There are many issues.
If the hearing could have been concluded, in a short period of time.
I guarantee.
But now I see that it'll take a
No, one second. So, if I guarantee that Lordship will pass an order.
You cannot guarantee.
One second. Because I am the.
I am there.
No, wait.
The same principle applies to you also. Understand?
Yes.
You have to be careful when I am submitting submissions.
Yes.
Okay. So my respectful submission is, Lordship, I will take 20 minutes and I say within 10 minutes this will, because the issue what they raised is res judicata, that once a dispute is referred to a tribunal and they passed an award, and then the same disputes cannot be referred to another tribunal. That is what they are objecting. That is why with great patience I have taken all the judgments here. Lordship, kindly see this.
Yes.
So I am just reading two Supreme Court judgments. There ends the matter. Yes. And that judgment, Lordship, and I also give a synopsis of arguments. If Lordship is pleased to take this, I will give a copy to them, and there ends the matter. Lordship, kindly take this.
My right to reply to it.
You have every right. Yes. But if Lordship permits me, I will give a written submission. So this will end. Lordship can easily pass the order. Kindly, my written submissions are so that they can be easily passed. Lordship, kindly see my written submission. So, kindly come to Lordship, page number 3.
Yes.
Page number 3, para 5, I was about to read DLF form, the same thing, para 18 and 19. During my reading, Lordship said, okay, if this issue, let me. So I am not reading that. That's the principle. Second is Lordship judgment. There, Lordship dismissed that application, section 8, for the ground that disputes were arising from the first agreement, whereas they have had a second agreement. Therefore, rightfully Lordship discussed. But Lordship has laid down the law in para 10. Kindly see that law. What are the requirements in para 10 of the judgment? It is Lordship may kindly see in page 39 40 in this compilation. Lordship's own judgment.
Yes.
That is in page 39. Lordship got para 10.
Yes.
Coming to the case of so and so, cited by the arguments for the respondent, giving conditions for which met, para 19, so and so, such judgment which is relevant for EC convent, the reproduce herein, so and so. And now, Lordship says that the first prerequisite is that there should be an arbitration agreement among the parties, which would mean thereby a subsisting agreement. The second requirement is that all the parties in the suit will be also parties to the arbitration agreement. The other causes will also so and so. So, whatever 8 applies to section 11 also, and so Lordship also has laid down the law so far as what are the ingredients of section 11.6. Now I have to show, now kindly come back to see the next in para 8. Para 8, Lordship may see. Page 3, para 8.
Yes.
It is also prudent to deal with the objection raised in the affidavit in opposition. It was contended by the respondent that the award was set aside on merits and therefore res judicata will apply. And the second reference of the same dispute is not possible. The contention is incorrect and for the following submissions. So now I submission leave it, I show the judgments, that is better. So that now kindly come to the page number 7. Lordship got para C, bottom. It is settled law that when an award is set aside for procedural irregularity, the same dispute can be referred to a new arbitral tribunal constituted. In support of the submission, the petitioner is relying on the Supreme Court judgment Jugilal Kamlawal versus General Fiber so and so 1962 Supreme Court 1123. And may I read from here, otherwise that judgment is item number 3. So, the contract contained arbitration clause in the following terms, because they say you cannot have a second, the same reference once is a dispute, because there is, in the arbitration agreement, there is no provision. That is their argument. Now, I am dealing this argument. All markets, this in that particular Supreme Court judgment, the clause says all markets, questions, disputes, reference or claims arising out of or concerning or connection with and or consequence of the relation to contractor, whether or not the obligation of either parties under this contract by subsisting at the time of such dispute, and whether or not this contract has been terminated or purported to be terminated or completed, shall be referred to arbitration of so and so. That Bengal so and so. So this is the clause. Now, under this clause, one award was made, it was set aside, and it was sent, Supreme Court said it should be decided by the subsequent tribunal, and no res judicata will apply, because here also there is, clause does not say that you can go for a second reference. Clause does not say that no arbitration clause will say if one award is set aside, you can, that will not be. Now kindly, I am reading 8, para 8, the relevant law. It is clear from section 16, section 19, I am pausing for a moment. Section 19 of the Arbitration Act 1940 says there is an express power for the Honorable Court to supersede the reference. In 1996 Act, there is no supersession power for the reason that section 16 gives the power to the arbiter tribunal to decide arbitrability first, then come to the court. Anyway, it is clear from section 19 that there are 3 matters which have to be borne in mind in arbitration proceedings. There is first the arbitration agreement. Next comes to the reference to arbitration. Lastly, the award. Section 19 provides inter alia that where an award has been set aside, the court may by order supersede the reference and shall thereupon order that the arbitration agreement shall cease to have effect with the reference referred. The section therefore leaves it to the discretion of the court when it decides to set aside an award whether to supersede the reference or not. It may not supersede the reference at all, in which case, though the award may be set aside, the reference will continue. But if it supersedes the reference, it has also the consequence to order that the arbitration agreement on the basis of which the reference has been made would cease to have effect with respect to the difference referred. It is only therefore when the court orders supersession of the reference that the consequence follows that the arbitration agreement ceases to have effect with respect to the subject matter of the reference. The intention of the legislature in making this change in the consequence to follow the setting aside of an award is clear in as much as the provision recognizes that there may be different kinds of arbitration agreements, some of which might be exhausted by the reference already made and award following thereon which may have been set aside, while others may be of more comprehensive nature and may contemplate continuation of the reference relating to the same dispute or successive references relating to the different disputes covered by the arbitration agreement. The legislature has therefore given, that is all under the old act. Now coming to that, on the kind after 10 lines, on the other hand, if the court finds that the arbitration agreement is of a general nature, ours is also general nature, and contemplates continuation of the reference with respect to the same dispute or the successive reference with respect to different disputes arising under the terms of the arbitration agreement, it may not supersede the reference, with the result that the reference as well as the arbitration agreement on which it is based survives. In such cases, there can be, in our opinion, be of no doubt that where the reference and the arbitration agreement survives, the same dispute may go before the arbitrators again, provided there is machinery provided in the arbitration agreement which makes it possible. So therefore, now kindly come to para 10. That's again. I don't want to open. It is not in dispute that the reference was not superseded in this case when the award was set aside in May 1953. It will therefore depend upon the terms of the arbitration agreement, in which case there was possible to have further arbitration with respect to the same dispute. We have already set out terms in the contract relating to arbitration. Lordship has already read that, no? That what is arbitration clause. And it is clear that term is very wide in its amplitude and contemplates reference of disputes as and when they arise between the parties to the chamber. Anyway, chamber we are not concerned. Next page, kindly see the next page. Now, this is the argument of the Leonard front, 1, 2, 3, 4, 5, 6, after 6 lines. It is, however, urged. Lordship got? This 7. It is, however, urged. This is the argument of my Leonard front. That this is a second reference of the same dispute. Yes. And this, at any rate, is not contemplated by the terms of the arbitration contract. This is their argument. In this case also, this is the argument. We are not impressed by this argument. Stress in this section has been laid down to that letter. Those words do not, in our opinion, show that a second reference was being made of the dispute. They say it is not second reference. The same disputes are referred because it's cancelled. Now kindly come to para 15. What was happened in this case is that the previous tribunal had made an award. The award has been set aside on account of misconduct. In the circumstances, we are of opinion that the previous tribunal has become incapable of acting as arbiter or decide this dispute because of misconduct. Further, as the reference has not been superseded and the arbitration agreement subsists, it was, in our opinion, open to the chamber on the request of the respondent to appoint another arbiter. This is what was done in our case under X. Therefore, as there is a machinery by which the fresh arbitration can be appointed according to the terms of the arbitration agreement, read with the rules of the Chamber of Commerce, and the reference has not been superseded, the appointment of the fresh tribunal and the carrying on of the arbitration further were within the terms of the arbitration agreement. Now, I say, in support of this submission, the petition is also relying on the following judgments. I am relying on 3 High Court. If Lordship wants, I can read, but otherwise, no, Lordship. One more thing, Lordship. Now, under the new Act, this is under the old Act. New Act I am showing, under the arbitration 1996. Lordship, may kindly see. Yes. There is no such power of supersession of reference when they are set aside for procedural irregularity or for technical default, and that jurisdiction is conferred on the new arbitrary tribunal constituted. It is the arbitrary tribunal which will decide the arbitrability of the dispute in the first instance. In support of this submission, the petition is relying on the Supreme Court judgment, McDermott International vs. Berne Standard. that two paragraphs. If Lordship is pleased, only I will read.
No, because otherwise this matter requires more hearing. I mean, I think Mr. General will have to, because this.
Lordship, what is that?
It's a very interesting point which this court doesn't want to deal with a short order. That's the only thing. Very simple to deal with short order. To say that there's an amount of second reference and then they let it go afresh or leave to the appellate tribunal to decide this issue. Very simple.
I leave it to Lordship, but may I say only one thing?
Down, yes, heard at length matters admitted for consideration. Just for hearing on.
Ask Lordship, please.
Yes, on so on. So we'll give the date.
That is.
You can appear virtually, so no problem, Mr. Thomas.
I can appear. So I am deep. So I will rely on my.
Yes. I mean, the judgments are very good. I'll have to examine them.
Yes, Lordship, exactly. Lordship.
I may be permitted to give a response.
Yes, of course.
Okay.
I'll leave that.
Is it before vacation or after vacation?
After vacation. We have only 2 days left, and because I'll not be here also till the 19th, 20th. Yes.
Okay. I'm deeply obliged.
Yes, what instructions?
Lordship.
They've handed over the land.
Handed over, my lord.
Is that correct, Mr. Khan?
Lordship.
You're not aware?
No, Lordship. As per instruction, the land has not yet been handed over, but the lease is going to be signed soon.
The signature of the petitioner is also here, my lord.
Yes.
You have not been instructed by your clients?
No, Your Lordship. They have been instructed that the lease from their side has been signed,
Yes,
but they're still waiting from the government side to sign the lease. That has not yet been signed.
No, taking over was already here.
Lordship.
Yes, Sir Lordship.
You take instructions.
Yes, Sir Lordship.
The land senior government advocate has produced a document, a certificate of handing over, taking over, dated 1st November 2023. Stop. Which shows that the possession of the plot of land measuring 13181.0 square feet at IDP campus has been handed over to Mr. Ashok Auto Service. Stop. Mr. D. Khan appearing for the petitioner prays him to obtain instructions on the said certificate. We give him a copy.
Lordship.
Yes, a copy that was made over to the consular petitioner. Of this matter after vacation, the certificate dated 1st November is taken on board and made part of the record.
Much obliged, Lordship.
Lordship.
You take instructions.
Yes, Sir Lordship. Lordship, if the matter could come up after vacation.
After vacation? After vacation.
Highly obliged.
Much obliged, Lordship.
If they've signed it, that means they've not informed you that they've taken over the plot of land.
Yes, Sir Lordship. I'll obtain instructions.
They've got pension.
No, Your Lordship.
Give them something for Christmas.
Pardon, Your Lordship?
Give them something for Christmas.
Pardon?
Give them something for Christmas.
Yes, yes.
You're giving.
There's already a communication with
No, Your Lordship.
with the let me be very with the writ petitioner number 1.
No, Your Lordship.
The President Board has not told you anything.
Before Christmas, we are releasing
He
something.
did not receive any communication from the respondents, Your Lordship.
We have communicated.
Let's see the communication.
No, Your Lordship, it was over phone. The writ petitioners was informed
That
before Christmas we are releasing some amount. It can go on board also. Some amount is being released.
No, Your Lordship.
And if no, then
You ask respondent number 1 on the phone whether he's
yes, whether there is a communication over with the chief.
Senior special counsel saying that you will be getting something.
Lordship, petitioner number 1 is.
Not aware.
They are not.
It's-
You are not in communication with the
We
number
are,
1.
we are related, so Lordship.
I'm very well aware. Yes. So you should be aware of what instruction he to receive.
He did not receive.
I got an instruction this morning from the chief executive member.
Leonard Senior Counsel.
And Lordship, next
For
year elections are coming, then code of conduct will come into
Yes,
place.
when elections coming?
Pardon,
When
Lordship.
will delimitation finish?
We are in the process.
No, when will it finish?
It will take a long time, Lordship.
So elections will be after that.
It will be after that. Maybe. I have no idea, but maybe.
So Mr. Vijayanta submits that the respondents have made arrangements for release of some amounts before Christmas, which has been communicated to the writ petitioner number 1. Stop. MS B.F. Karwanlang, counsel per the petitioner submits that she is not aware of any such assurance. Be that as it may, we expected that before Christmas some amounts be released to the writ petitioner. This matter after vacations.
Same order in the next item also.
Highly applied. Item number 7.
I'll be appearing on behalf of this contempt, my lordship.
Complaint.
Not yet, my lord. I'll be appearing on behalf of this contempt number
fresh.
7. Yeah, fresh. Yes, lordship.
Yes, Mr. A. Abraham has entered appearance on behalf of the
contempt.
Only one of respondent. You pray for affidavit?
Yes, lordship.
You pray for allowed 2 weeks time to file affidavit. List thereafter.
7 and 8 connected, yes, lordship. 7, 8 on both the cases, I'll be appearing.
9.
How much payable?
Yes, Lordship.
How much payable in this situation? Where's Mr. Pandey?
He's out of station, Your Lordship.
Then?
Your Lordship, this matter was referred to Lok Adalat, Your Lordship.
What happened?
But since the petitioner has received a notice lately, Your Lordship, so she could not appear. So I therefore pray that it may be referred again to the Lok Adalat for settlement, Your Lordship.
No, let it be listed again.
Yes,
matter was before Lok Adalat, but due to non-appearance of parties, the matter could not be settled. This after publications of further orders. Tell Mr. Pandey how much CRG do you think is admissible, and we'll decide.
Yes, Lordship.
10.
Yes. Reply betul. Betul ada betul program reply. India.
Lordship, I seek some more time, Your Lordship, for
How
a
much
joint
time
affidavit.
you have taken?
My lord, this is the third occasion they have taken.
Third time, okay. Further 2 weeks time granted to the petition of Harijana.
Duly obliged.
That's great.
11.
Lordship, I am for the private respondent. I pray for some more time, Lordship.
No, final opportunity given.
Last chance, Lordship, as a last chance.
When after final is another thing goes last chance.
So
You pay cost to Mr. Debnat of 1,000 rupees, or pay to legal service authority and will allow to file affidavit.
Some more time may be given, Lordship.
Why? What was the difficulty?
Because I have applied some documents through RTI, Lordship. I mean, yeah.
By order dated 20/11/2023, respondent number 4, represented by Mr. S.A. Sheikh,
my salary
was
is not
allowed 3 weeks time as a final opportunity to file affidavit. Stop. Next paragraph. Today, the affidavit is still not on board. Mr. S.A. Sheikh has renewed his prayer to file an affidavit, as he submits that the necessary information is still awaited, which has been applied through RTI. Stop. Next, in this view of the matter, as final possibility been granted for the ends of justice, further 2 weeks time is granted to respond of 4 to file affidavit, subject to payment of rupees of 1,000 to the Meghalaya State Legal Service Authority. Yes.
How much this current salary was paying?
What to do?
12.
Sorry for you. But it's number 4, affidavit is necessary. Yes.
This is the matter where my learned friend had
transfer.
Mallards. It indicated some application was coming, Mallards. Your lordships had granted them some liberty.
What application is coming?
Mallards,
for confining the interim order only to the petitioners, my lord.
Lordships would recollect on the last occasion my learned friend wanted some limited modification.
But where's the application been filed?
My lord, it has not been filed.
Not why?
It is in the process, my lord. It is sent for vetting.
Too bad then.
My lord, in the writ petition, we have filed an affidavit, my lord.
If you want modification of the interim order, Dr. Mozika has to state as such, so the court can pass, like a definite order.
But I'm not pressing for that, my lord, today, my lord.
What are you pressing for?
They filed a counter, Mallards. I'll file a rejoinder.
Yes, sir. In the main case.
My lords.
Item 14. In the contempt, what should we write?
Let's contempt can come along with the main case.
329, 23. Main case. An affidavit of opposition has been filed by the respondent stuff. Next para Mr. K. Paul pays for about 3 weeks time to file a joinder. Just thereafter and so on.
Let's the interim order may continue.
Interim order will continue until the next day.
Modified. Yes. So lots of extending the interim order can be modified to that extent.
15.
You have to make the
for that the application would have to come first.
Yes.
Well, this is the transposition, my lord. But only one aspect of the matter, my lord, I wanted to.
They have taken time for filing the board resolution, my lord.
Yes, we are filing that also.
So I don't have the copy, my lord, of board resolution.
I am representing the BCS, my lord, who is the petitioner number 2, who is wanted to.
The board resolution is there.
Board of resolution is with me, my lord. I got little late.
Why you didn't file it?
My lord,
You would have taken the court have passed orders today only.
My lord, I may just pass on because it's one page.
Your lordship, I need time to go through that day, and your lordship may have it on 19th or 20th.
My lord, only one aspect, my lord. I just wanted to point out one aspect of the matter, my lord. Your lordship kindly comes to their own tender conditions, my lord. Your lordship kindly.
I will do one thing. Dr. Bhaskar will pass orders, but since I'm not here, I will pass on the 19th. I mean, I don't see. The only thing they've taken is a hyper-technical objection.
My lord, only, my lord, if the transposition was allowed today, my lord, then the matter could have been heard.
Mr. Advocate will allow.
Your lordship may take it the matter of 19th, my lord.
We will allow it, yes. You find a board resolution.
Your lordship kindly see 19th.
Because the board resolution. This is just a technical objection.
They have not given me a copy of the board resolution. They could have given me the copy of board resolution the morning. They have not handed over, my lord. Kindly hear me on 19th on the board resolution also, my lord. Because this is because they were supposed to file before, and they could have given in the morning also, my lord.
Yes, a certified.
They could have given in the morning also.
Okay, a certified true
it's
copy.
Like doing something behind my back.
Order. A certified true copy of the resolution passed.
No, I don't have the copy, my lord. They have not given it to me.
PCITS Private Limited, held on 24/10, has been produced before the court today. Stop. The learned Mr. E. Kumar, appearing for the Respond Corporation, has submits that he has not been favoured with a copy of the same. Only copy made over, matter be listed for orders on 19th.
On 19th.
All on that day.
Yes. Okay.
But only one thing, my lord.
Correlations taken on board.
The
Yes.
learned AG is referring to a certain decision which my lord, if I can read a few lines from that.
I will argue the matter in totality. I will argue the matter in
The only thing
totality.
is on technical, you have not been able to meet the technicalities. If you met it, then what remains?
But now
all courts say, show me the law, take the order, that's all. What can the court do?
My lord, that is what I was trying to say, my lord. But my lord, because we are,
you won't be here.
We are approaching closing, my lord. That is old.
No, 19 will pass order.
19th we will argue the matter.
Yes.
My lord, since my lord has taken on record the board resolution, I
You need to file it. Yes.
Let my friend give a copy now also. I have not received a copy. Let my friend give a copy to my colleague.
What's happened to him?
We have given knowledge.
MS R. Kolni is here. Where is she?
Hotline.
You only sent.
16.
Yes, R. Kolni.
Lord, I pray for some
7,
time
8 to 12, yes?
to file affidavit.
You filed?
No, not yet.
Yes?
My lord, I do not have the copy of the writ, ma'am. We have not received.
That is your problem to have a petitioner.
We are not even aware
You already
that we
served
have to
it,
make a
Lordship.
party in this particular case or something.
Already served. You already served a copy.
Very good. Then you,
My lord, I have
for a 2 weeks' time, granted the respondents to file affidavit. This thereafter.
17.
May it please yours. My lord, we are filing reply. We are filing affidavit raising objection as to the maintainability of writ petition. The affidavit is ready, my lord,
ready.
and it is being filed.
My lord, we'll serve the
What is the matter about
This
Mr.
is regarding about my lord ideal project
two projects.
Oh, which were abandoned.
Yes. Now I have got some judgment of Supreme Court in 2023. My learned friend is raising the plea of mentability, whether it can be relegated to a civil court. Now there is judgment of the Supreme Court which make very clear, my lord. Unless there is an affidavit filed by them, which are the area with a disputed question, your lordship will not be able to decide that issue. So they are coming with affidavit. Coming with only what apprehension is there, they may give it to some other, either express of interest they may call for. That's the whole problem. That's the whole problem. Your lordship has said two things I just remembered. One is whether it is a civil consequences. If it is a civil consequences, whether a notice is required or not. Even in spite there is a disputed question of facts. Now that makes very clear of the judgment of the apex court. Only what I want, a very limited, let a status quo order be maintained. Let them not go ahead with this, my lord. Only a status quo order I am asking, my lord. We'll give a reply.
I will argue on his writ petition only, my lord. There is no case at all, my lord, on merit. There is no case of whatsoever. Prima facie also not.
No, we will argue. You give a reply.
That's affidavit. We are getting it signed by the officer, my lord. We'll be able to file in few minutes.
In a few minutes.
My lord, it's getting notarized, my lord.
For the interim order, my lord, your lordship will keep it on 20th.
We have it on 20th, my lord, or 19th, my lord. I will argue the matter finally. It's a very short matter, 2 minutes matter, my lord.
Very simple for you all to say 2 minutes, but
what the issue is,
in this case, I thought it'd be over 5 minutes.
I explain the matter, my lord.
The contract. He may say 2 minutes, but I know what is the difficulty of court. 2 minutes, very easy to say.
The contract will come to an end in 2015 only, yes. And they are trying to stall the further progress in the state of Meghalaya.
I'll give a reply. My learned friend, I will give a reply. I have not started. AG, I have not started.
Okay, no need to get excited. It's all right.
Not your case.
Yes, not yes.
Whichever is convenient, my lord. I know, my lord. Convenient for your lordships.
Because they have to. I have to go for the petition for the respondent corporation. That means respondent number 3.
My lord,
You're filing for the MEC or for the state?
My lord, power department, my lord, AG.
For the respondents 1 and 2. Submitted that the affidavit will be filed in the course of the day. Mr. E. Kumar, for number 3 or for number 1 and 2?
For all the respondents, my lord.
Mr. The Archivist General, all the respondents have submitted that. What is the submission? No submission.
My submission, Lord, the contract has come to an end in 2015, and this is the admitted position. Secondly,
come to an end 2015, no further vested right.
And second, what they are saying,
to the writ petitioner, Mr. D. Das, counsel, and that involves disputed questions of fact. Next paragraph, Mr. D. Das, Senate counsel petitioner, senior counsel, however, has vehemently raised objections and submits that there are decisions of the Honorable of the Supreme Court that speak otherwise.
Yes.
So, I'll call this matter for admission hearing on reopening. In the meantime, any further action of the respondent subject to further orders of this court?
I'm deeply.
Yes.
Deeply.
18.
Can a date be fixed?
You please take a date of court, master.
I'm deeply. I am for respondent 1 to 4. Now waiting instruction.
Mr. Keyboard participant prays for not 2 weeks time to obtain instructions to file affidavit.
Private respondents are also there.
They have already taken steps. You've taken steps. Yes. It is submitted that steps will be taken on private respondents, however, not received. So the report still awaited. Stop prisoners permitted to obtain status and to file affidavit if necessary.
19.
Please, Your Lordship.
My Lord, we have received instruction, my Lord, just submitting a copy of the instruction.
You file affidavit then? What will happen now? What does your instruction say?
My Lord,
where's Mr. Jindal?
Inquiry is being...
Your Lordship, may I please, if Your Lordship could take up this matter at the end of the report, Senior Conducting Consultant
Anandakotum.
My lord, inspection has been conducted in this case at page number 9.
Was he present?
Yes, manager was there, my lord.
Does he have a copy of? Do you have a copy of the inspection report?
No, my lord.
They don't have.
They don't have.
You didn't given them why?
I have just received, my lord. So I'll supply a copy to them, my lord. We'll bring it on record by affidavit, my lord.
This is matter on 20th. Instructions have been received by the government council. Instructed, he is directed to place him by affidavit list on 20th positively. List on last day.
My lord.
You take it back. There's an inspection report that shows that you should take permission from DFO, not from Deputy Commissioner.
Much obliged.
Second call, supplementary list, item number 3.
My lord, this matter relates to creation of a new village. It is a Maunai village, my lord. Maunai village has a vast territory. Now the Maunai Lingdo, it is one of the dominant clan.
You are whom?
We are for the Maunai clan.
You own all the land there?
We have. Now what happened is this. The Maunai village has decided to give, to create 2 localities into villages. And that was informed to the chief.
From Maunai village?
Yes, chief. And when they informed to the chief in 2018, the headman of the Maunai village said that way back in 2014, we have decided to create a new village. So please form the new village in 2018. Now, we raised an objection that most of the land been owned by us and no consultation, there was no proper meeting. So in view of that, my lord, the chief has referred the matter to the executive committee, seeking their intervention. And the matter went to district council. During that time also, my lord, that these 2 new villages yet to be created, my lord, they sought for issuing sanat from the chief. The chief said, no, we cannot issue sanat because the village is yet to be created. Matter reached to the executive committee. Now, executive committee, my lord, under the Act 1991, they have the power to approve. But creation power is vested with the chief and his lordship is very much aware. Now, district council in the Bunjo order, Lordship may they directed
only one question. Now, creation of village means it has to have the assent of a parent village and the residents. Was the exercise conducted?
According to me, there was no such exercise.
According to you, meaning?
Yeah, according to the writ petitioners and his clans, there was no such exercise in 2014. And
no, but the thing is that just there was no, that means it was just by itself arbitrary decided to create a village.
In 2018, therefore, after 4 years from the date of decision, so-called, headman has forwarded.
Forwarded the what decision?
Forwarded a letter to the chief to create a new village for these 2 localities, saying that in 2014, 4 years back,
decision to create
this decision has been taken place.
And that's been approved by the chief.
And chief did not approve. Before he has given his approval, we raised no objections. So he was unable to take a decisions. Counterclaims are there. So he has referred the matter to the district council. In fact, he should not. He has the power to decides. But he sought the intervention of the district council. And district council has taken a decision that we have perused the entire history of the land and the culture, and therefore this upgradation of these 2 localities into two villages is correct. Therefore, district council hereby directed the chief to create a new 2 villages. So according to
now
me,
your contention, I think, by the petition that the whole creation is illegal without due process.
My lord, my contention is that district council has exceeded its power. They don't have the power to direct the chief to grade. Only they have the power to approve. First, chief has to apply his mind, the disputed claims, both the parties, and he can take the final decisions, either grade or not grade. Thereafter, if creation is made, approval will come to
Where's the impugned order?
Impugned order, may I take, Lordship? Page number 39. Page number 39. And in a lengthy order passed by District Council, I will come to Lordship, page number 44, para 4, para 8, relevant para, my lord.
Yes.
And sub-para 1 merit.
Yes.
The Executive Committee, through the Deputy Chief Executive Member in charge Laga, has convened a meeting between the parties in the presence of the Chief of such and such. After the examination of the documents, the clarification and evidence, the Executive Committee KGTC has decided as follows. The decision of the third party Maunai village for creation of full-fledged village to such and such localities is found to be satisfactory as per the KGTC Census 1991 Act, whereby for the creation of any village, the approval of the parent village as well as the desire of the villagers are required. As per the law stated above, there has been no mention that prior approval from any clan who are the founders of the village is required. It is also considered expedient to bifurcate any village as per the requirement of time. Therefore, the notification issued by Census acting chief Census in 1996 is without any basis, that there should be no more creation of new village in any village. The Executive Committee has directed the Chief of Census to send its approval on the request for creation of new villages.
Okay, so the council has found that it was done as per due process, and that you as a clan have no locus to challenge the creation of villages, correct?
Yes, that this council is saying. And this council said that direct the chief to send the recommendation and approval. In fact, when my lord, I have submitted the list of the act, only section 4, my lord, it is very clear, lordship may invite lordship attention to section 4 of the Ilagai Act.
Yeah.
Madam. Section 4, lordship, where is it? It says, madam, the chief and his third part, with the approval of the Executive Committee, may, if the majority of
section
the
3, not section 4.
Section 3, but I'm still correct. If the majority of the people of the village or villages so desire, by public notification, form a new village by separation of territory from any village or villages, or by uniting two or more villages or part of villages, by uniting any territory to a part of any village. So according to me, my lord, creation power is vested with the chief. He has to apply his mind. He was yet to apply his mind. Now when there is situation at that stage, now this
we have to issue notice to the chief then, if he's a relevant, very important party. But Mr. H.L. Chandran is here, counsel for the petition, assessed by so-and-so with the petition issue notice. Mr. B.G.K. Ganta, special counsel, is present on behalf of the respondents. 1, 2, no further notice called for, respect to respondents. Petition takes step for issuing of notice on respondents 3 and 4. But it's AD within 3 days. Just thereafter on 3, after 3, returnable 3, just after 3 weeks. Yes.
After 2 weeks, madam. I filed in this case to maintain the status quo, madam. Otherwise, they'll create a new village and there will be confusion again.
Even so then, I will not pass any orders regarding that. More problems, yes.
If he creates there will be a confusion again.
See, because the thing is that what appears from there, notwithstanding the authority of the Executive Committee to approve or to create new village, is that there's a finding that the villagers have on their own, I mean, there's a majority have decided that they want to have their own villages, number 1. And number 2, also, the Act doesn't say that, the clan that's created a village or something will have any say with regard to whether a village can be created or not. So if your locus, in fact, is in doubt, so how can we pass, interim orders restraining, that's the thing. So we'll just see, interim order will be considered, interim period considered on the next date, after appearance of respondent 3 and 4. Let them appear. I understand, but then, see, if you're very locus, the Act does not provide. The Act looks only at the citizens or the inhabitants of a village. That is the thing that troubles the court. Otherwise, there is no status quo. It's not a problem to pass. It should not create problems. Yes.
Item number 4.
Yes.
Item number 4, day before yesterday, Lordship was inquired whether the status of my complaint, the complaint against me, whether CM has
Where's
passed
the order, Mr. Jirwa? Oh, Mr. Kiran. Order of immediate disposal of complaint.
Order has been passed, Manoj.
No, but has he received a copy?
Yes, of course, Manoj. Yes, annexed it with the writ petition also, Manoj.
Where is that?
Annexure 8, page 102.
He said that complaint has not been disposed of.
It is not the complaint. Lordship, may kindly see.
Page?
Page 102.
Complaint is page number 78. Lordship, can you see? 78.
Yes.
And after that, notice was issued to us, page number 91.
Okay, 1 second. 78 is your complaint?
Yes.
Okay, fine. Dated
91 is
August.
the notice for me.
19/8. Okay, then
for him.
The notice issued, which date? No, sorry. The notice issued on?
On, my lord, 1st September 2023, page
Okay.
90,
Yes.
by copy. And the hearing took place on, my lord, that is page number 92. Hearing took place on 8/9/2023. Lordship got it. Page number 92 of the writ petition.
92, yes.
The hearing on the complaint.
Yes.
And the decision taken by the next page, 93, the last second paragraph. My lord.
Yes.
It says, with regard to the Sanat, Rangpashno has shown that Sanat has been expired. The Madhya has shown that the Darbar Hima will also take a final decision. Has requested the village headman that he should temporarily halt with regard to land governments, and if there is any urgency, he must consult the village. So they say they will take a final decision.
No, that's Darbar Hima. You talk about that.
Darbar
Order
Hima.
number 4 is Williams. Number 4, correct?
My lord. This
So
is
he has
the
taken a decision. Darbar Hima is a different entity altogether.
Darbar Hima, my lord. The complaint was placed for Darbar Hima.
Even the
And now, same of William. And now same of William has heard the matter.
William, so decided the Barhima is a different entity.
But it is not my humble submission. It is not decided. And Lordship, my friend has referred to page number 102. He said that this is a decision. But decision is altogether different, my lord. It has no reference with the complaint.
No, this is the order passed, he's saying. This, excuse me, that 92?
92, page number 92, Lordship is referring. They say that they will take a final decision.
No. See, Mr. Chareso, it says that the finance secretary is also reference that if they said that, where's that part you're reading?
My lord, the last second paragraph.
The Sanat.
My lord, with regards to the Sanat, Rangpashno has shown.
Has expired.
Yeah, expired.
Yes.
So that the Darbar Hima also will also take a final
Will
decision.
also. Darbar Hima it is a different entity.
But it is a
the
chief.
only thing that in your case that number 1, you had a Sanat for 1 year. You have not been terminated during the subsistence of the Sanat. It comes subsequently. There is some complaints that has been addressed, whatever. Now let there be elections.
My lord, my complaint is not yet addressed. My complaint is still there.
No.
And the decision itself here, it is very clear. They are yet to take final decision. And the impugned order passed by the chief, page number 102, Lordship can see.
Election, see, Mr. Chareso, the things that let the public decide if you have the confidence.
But that is true. But the system, my lord, the remaining others, they renew. And chief admitted.
No, see, there's a convention. Court keeps on saying the convention is not enforceable in law. Only in England you can enforce your convention.
That is my lord, that is the customary practices out there, accepted by all the 5-6 villages.
You can't take convention as to be a factor which will which is what is an actionable factor that will warrant orders of the court.
Just 1 minute, my lord. The six villages came together.
The elections go ahead.
They formulated the constitution, make it as a 5-year term, because election every year is not feasible at all. So district council, the chief.
We understand that. Not that you don't understand, Mr. We understand that for whatever it is 5 years, but they made 1 year extendable by 1 year. But if circumstances exist that that does not make it feasible to extend, and they call fresh elections, then you go to the public if they have, as you say, now you're in office first time because they had faith in you, correct? So if still repose faith in you, why won't you continue?
No, but that is true.
If they have lost faith in you, then let the public decide. Even in Parliament, is a floor test is the most important thing.
That is true. But no one raised complaint against my 1 year tenure.
I'm afraid the court can't grant it.
My lord, appreciate this position. There is a discrimination to 4 persons.
There's no discrimination. It's a convention only.
It is that, my lord, it became a practice day, and if they don't follow.
One thing is, let elections go ahead. We will leave this question. We'll decide later on if you want.
My lord, lordship, my lord. They let them, my prayer is, my lord, let them file a short affidavit. Maybe this was at admission stage. It requires consideration.
See, the thing is that you're not even sitting in the seat anymore. It's being looked after by administrators, correct?
Administrator is
appointed.
Let's
not suffer also.
Therefore, I'm not coming back seeking for my returning. Let the administrator continue to look after. And within 2-3 months, let them file affidavit, my lord.
We'll pass orders. I will dismiss the petition. I'm sorry.
Petition may not be lordship.
We'll dismiss it. I mean, hence elections, court's not ready. This interim order also was anyway.
Today the matter came up for interim matter. If lordship, my lord, pass necessary order, but with regard to petition, my lord, lordship may give his time to address that issue on the merits.
I think you're
on the merits. Otherwise, they cannot do this. Complaint, nothing is there against me with regard to 1 year tenure. 4 headmen, they renew it. When it comes to me, expired, they remove it. And my complaint is still pending. My lord, I will address, my lord.
My lord, the same authority which my friend is submitting but sought for his renewal, they themselves have sought for new fresh election, my lord. The Umsning Town Darbar, my lord.
Whatever is, once elections, court not inclined to stay in elections.
The recommendation is there. Lordship, 104, the recommendation.
We'll pass orders, Mr. Chani. So
Yes.
You can pass open court if you want.
Well, not only my prayer is with regard to main case. If Lordship give me one more opportunity, that will be grateful. Grateful. I'll try to satisfy it. There cannot be discrimination, man.
Okay, take down. By order dated 29/11/2023, this court, on the submissions of the counsel of the petitioner, that the complaint filed had not even addressed, and as the sanad of other headmen had been renewed, was pleased to stay the order for was pleased to stay the election proceedings, which was to be held on 30/11/2023 for election to the post of headman of Umsning.
Paratim village. Paratim village, Umsning.
Paratim village.
Paratim village. Umsning.
Stop. Yes, but today, from the respondent side, it has been shown that there has been a clear finding by the respondent number 4 on the complaint of the petitioner after hearing that the sanad isn't expired. Stop. It is also noted that the concerned village, in view of the interim orders and the situation prevailing therein, is under the administration of a Mantri of Hima Millim. In this view of the matter, As nothing remains for consideration at the interim stage, the order dated 29/11/2023 discontinued, and the respondents at liberty to announce and conduct fresh elections to the post of headman Dong Patarim. Dong Patarim?
Patarim village, Kumsni.
Further, as Mr. Changreso submits that a larger question is involved with regard to the convention that is prevalent with regard to renewal of sanads automatically, let this matter appear after vacations for hearing stuff. It is like last time. It is further reiterated that the elections should be held at the earliest, and there shall be no bar on the petitioner contesting the same. Yes.
Election result would be subject to the outcome of the request. What should I make that observation?
You know very well you are a seasoned counsel. The matter, your term is out and this and that. Just
satisfied that
Christmas bonus already given you. You can take part in elections. Yes.
We will address.
Yes, the parties will be allowed to file in the meanwhile. You can't stay elections. Let the public speak.
Hearing. Item 5.
Yes, what is the urgency, Dr. Mosika?
My lord, the tenure of managing committee is expired, my lord.
Matters will become infructuous, my lords. This is that matter concerning the...
Then we'll close it.
The matter can be closed, my lords, only we were praying that...
Let them be constituted a managing committee at the earliest.
As per rules, my lords.
Parties submit that the matter has since been rendered infructuous as the managing committee has, as managing committee's term has since expired. Stop. In this view, the matter with which stands closed as being infructuous. However, with the direction that the fresh managing committee be constituted at the earliest in accordance with law. Ballots. 6 also same. Very good.
Daily list item 20.
Your Lordships. Well, this is that after vacations. No time to part with the judgment because I'll be traveling. For the request of party, it is a matter of vacations. It's part heard.
It's part heard. It is hard on several occasions, Your Lordship.
He's successfully tackled your. He's like a footballer, no? He's not allowing you to score the goal.
27.
Even though you have a very strong team. Where's Mr. Deb? Where's Mr. Deb? Mr. B. Deb. You're paying for respondent?
Yes, for sole respondent.
See, Mr. Deb has been, studiously avoiding this case. Hey, yes, we'll dispose it of today.
Lordship,
yes.
Your Lordship has already heard the matter, and Your Lordship has observed that there is no merit in the case. So, Lordship, I have a very small prayer that I may be allowed to file written argument, Lordship.
Written argument for what purpose, Mr. Deb?
Lordship, this is my limited prayer, Lordship. I may be allowed to file written argument.
The court doesn't consider written argument necessary.
Even I have prepared also, Lordship. Today itself, Lordship, I will be filing, Lordship.
We have made oral arguments. We'll let you breathe one more after vacation. Take them 50,000 offering you. You'll get zero. Yes. She doesn't understand that.
Pendency of this case is creating problem for all of us only because office is not processing the other dues and she is also not getting. I am also not getting. It's been taken in sabotage only.
You take that 50,000.
We are ready to give today also 50,000, and that is what my late husband has been paying to her also. So we are honoring that. We are honoring, in fact, the order of the district council. Of course, it doesn't survive anymore, but we are honoring that. We are
honoring. Avoided hearing now. How many dates? Let's see.
Yes.
Yes. Unwell. Why are you avoiding the court then, Mr. Zeb?
Lordship, today I have very limited prayer, Lordship. I will be
no,
allowed
not
to
limited prayer. Why been avoiding this court? October, November, again in 1st of December. You this is the matter's been heard. You said what to do? To obtain further instructions.
So my
because they made an offer, we heard the matter. There's no case. So they made you an offer that just settlement take 50,000 enough. You're not willing to take that also.
My instruction is that they are not willing.
You don't, sir, good lawyer doesn't go by instructions. If it's in a point of law, the clients listen to the lawyer. Not the lawyers. The client says that black is blue, and you say before the court you say black is blue. It doesn't work that way. On facts, you take instructions. But law is for the lawyer to apply his mind. Right?
Yes.
Because the law follows the facts also. It's like that simple as that. So it's up to you. You apply the correct law and you see that this, if your client can get no relief, you have to be very fair and frank with them. That is how much you can expect and what you might get.
I have made them understand,
but you don't understand.
Yes, Lordship. So today I have very limited prayer that I may be allowed to fight the general argument.
No written arguments. Let's see what you've written.
Same thing, Lordship.
Same thing, the petition. How? What's the point? Yes, show me what you've written. Sure. I understand your anxiety but you have no materials to substantiate your. That's the only thing. I don't want to reserve this case for judgment also. That's the thing. What to do? She won't listen to reason.
Yes, sir.
No.
Yes, sir.
Your client won't listen to reason.
I have explained, but they are saying that with 50,000, what I'll do? Because when my husband was there, he was per month, I was getting 7,000 as interim maintenance. So during the pendency of the maintenance petition, my husband was.
The case is over. Now he died.
So
and you have no material to show that,
Even Lordship, she's saying that what I'll do with 50,000.
Okay, just since it's nearly Christmas time, so Mr. Bidep today has filed synopsis written arguments on behalf of the petitioner. The same taken to record. You give a copy to the.
Yes, I have supplied.
Yes.
All right.
29.
I'm sorry, reserve judgment. Yes. What's the matter about?
It's in connection with the deleting of my name from the SSA post, Your Lordship. But Your Lordship, on the last date, the state concerned party have directed to file the affidavit, but...
No, last time, who's respondent number 5?
We have to file, and we have already filed a affidavit.
When?
We have bring on the record.
I've received, Your Lordship, on the 16th November 2023. But as per my understanding, Your Lordship, I think so the state concerned
the state file affidavit
is to file the
yes,
affidavit.
File it, but again, this honorable court has passed some order for getting some more information. I have sent this WT message.
Where is that?
I have not received any communication till date.
Your Lordship, order dated 18/10/2023, where the...
Oh, yes. Why you have not come to instructions? 1810 said after hearing some length, the following instructions are required. Number 1, who are the approved sanction teachers of the K or RCUP school? 2, when were they approved? 3, whether selection set have been conducted on 22/3/2020 was ever communicated or approved by the concerned respondents.
I have already communicated on 19 October, my lord. Till now,
Take down by order dated 18/10/2023. this court had directed the GA to obtain and other respondents to obtain information on the pointed queries which have been listed therein. Stop. Next one. However, as pointed out by MSM Yaosai, the set instructions are yet to be. The instructions are yet to be received. Sorry, asserted by Mr. Ezarikan are yet to be received.
And
accordingly, it's expected before the next date. Yes. Before the next date, the
And Your
instructions should be
Lordship,
received.
the urgency in this matter is since the last 1 year I'm not receiving salaries and I have to look
Now
after
schools are
5
closed, can't do anything.
minor children, Your Lordship.
Is she entitled? to any
No,
salary?
Your Lordship, we have.
Please, sir, my lord, as per our.
She's fourth teacher, so.
So you've been paying the managing committee. That means
We paid from managing committee, but now we said that we ought to already inform her that because after COVID we don't take any salary or fees from the students, so it's very difficult to.
Your Lordship, the school is very much functioning and she is still teaching, even till date, Your Lordship.
No, Your Lordship, from very beginning of this academic year, we already informed her that please stop coming to the school. But she didn't listen to that.
She's coming to school. You think sign register.
We didn't give her any jobs.
Your
Are you
Lordship,
signing register of attendance?
yes, Your Lordship. Even the routine.
I think she maintained by privately, but in the school.
How can you maintain the school register privately?
No, we inform her that to stop coming to school. And
See what is done in these schools, we understand also, though it is informal. With 3 sanctioned teachers, the pay is engage more teachers, and the pay is paid from there or from managing committee resources.
Yes.
Doesn't mean that with 3 sanctioned teachers there can't be any more teachers. Whatever, if she's been rendering a service, she might be entitled to some money. You have terminated her just like that.
Because
people stop coming to school.
Yes, we.
And Your Lordship, if we have to go for hearing, the affidavit that have filed by the respondent, in the year 2020, they have sent the name of the other teacher for approval.
Yeah, it should
After
be
I
heard
have
then.
raised the issue, Your Lordship.
Yes, Atharva.
However, it is pointed out by Mr. H. Azarika that instructions are yet to be received. Accordingly, it is expected that instructions.
And then by the next date, the said instruction should be on board, should be received or filed by way of affidavit. So this is a matter of notifications.
Your Lordship, my prayer, if they can be directed to pay me a salary, Your Lordship. My 5 minor children and I have to spend Christmas, New Year.
Very difficult.
Okay, Your Lordship.
You pay from your pocket, Mr. Karimda.
We will try all this. Yeah.
Very difficult. And I'm not making direction.
Pursuant to the directions passed by Your Lordships on the last occasion, some affidavit
Affidavit
has
you
been
filed.
filed.
Lordship, we
They
filed.
filed an
Have you got
affidavit.
Received.
I've got an affidavit, my lords, but Your Lordships may kindly have a look at this affidavit. It's neither here nor there.
No, but the map is there.
Yes.
The map is here.
And it further indicates the stand of the respondent number 6, my lord.
It will be unending.
My lords, there is a map which does not even have a legend to show that which is the north. This is probably the first time I've come across a map in my life that does not even have the north.
And you see that room door.
At page 9, if Your Lordships kindly have a look at it.
Yes.
As we don't even know what this map is all about.
Not
Blue and red, blue and yellow. Red is border, small single line is other road.
Now, Your Lordships may kindly, I'll just draw Your
What
Lordships.
objections do you have to the map apart from the legend of North-South?
Well, it's what it basically says, if Your Lordships kindly have a look at the vermins. Paragraph 3, my lords. That this instant affidavit is being sworn to bring on record the list of roads under the Public Works Department, roads and the map indicating the export route as directed by this Honourable Court. Now, Your Lordships will kindly see Annexure 1. At page 5.
Yes.
Now, this is an extract of which document, my lords?
Sora division.
We don't know.
Yes.
This has to be an extract of some document. It cannot be just taken as the gospel truth, my lords. They have to say, what is this document? It does not say. It just says it is a list. Now, the orders that had fallen from your lordships on the relevant day, my lords. The lordships will kindly take the order dated 18/10/2023.
What remains the matter actually, Mr. Paul?
My lords, everything remains. Your lordships' last order is very clear on this.
1810.
My lords, if your lordships kindly have page 4, paragraph 4.
Yes.
The respondents are accordingly to supplement the submissions to clarify the matter and produce necessary records is necessary on the next date. Now, what records are these, my lords? On the basis of what your lordships are to adjudicate? I think there is a typo error.
Yes.
So, your lordships, we would have to understand first what are these documents. If I have to respond to it, I have to first.
Okay, Mr. Shula, you supplement the affidavit. You correct the legend and then we'll have it.
Yeah, and the other thing is, my lords, this map, what is this map we have to understand?
This is we know where, because this is a disputed fact. Where have you just write down where that extract has been taken out from whatever, and then that and the corrected copy.
Because my lords, only when they disclose what is this document, then I'll understand.
This is the list of road, your lordship. So far, the Sora subdivision.
No, where is taken out from where?
Lordship,
that is, the objections have been raised by the senior counsel as to the contents of the affidavit file. Yes, as we file stop. Ms. Andy Shula Island AG is directed to supply the details as to where the extracts have been obtained from. Yes, that's also legend to the map, the sketch map. Just after vacation. No point.
The entire exercise is defeated with this kind of an affidavit coming in.
32.
That SC certificate?
OBC certificate.
OBC. What to do now? Should the court make a pronouncement that the OBC issued from Assam will serve to be, even though there's no OBC in Meghalaya? Mr. Sangman do better, he lost category before. There's no OBC status in Meghalaya community. So what to do if Deputy Commissioner issues a certificate that the person's OBC?
Your Lordship, it is normally there is a central government notification regarding this matter. That,
which one is that? You take it from him.
Because exactly I don't have at present, I have to find out.
Well, on what authority does the Deputy Commissioner recognize the grant certificate by another? See, what's happened here is that he's got appointment in the OBC category, but the thing is that the OBC certificate from Assam, that has been reiterated by this Deputy Commissioner here. They're not accepting it. Simple as that.
Yes,
as the person still for employment, why deprive him?
Of India, sir. For that, there is a notice
from the
government of India.
Mr. Sangma, he was earlier law secretary. Just after vacations, that to enable the petition to obtain further instructions. If that's in your favor, then well and good. Okay.
$39.
Where's Mr. Abraham?
My Lord, we have already filed our additional affidavit also in this case.
What do you say in the affidavit?
My Lord, this was with regard to those 12 numbers of staff who were appointed on the labs post, my Lord.
On the?
On the labs post, my Lord, here. Labs
Okay.
post.
Your Lordship, I'm producing one letter, Lordship. today, Your Lordship.
You received one letter?
I'm producing one letter before Your Lordship.
You're appearing this matter?
My Lord, yes. Item number 39 and 40, my Lord, Additional Advocate General T. Youngie is leading this matter.
Same matter?
My Lord, yes.
Your Lordship, this letter is issued by the Deputy Secretary, Personal Department, Your Lordship, stating that to submit all the appointments on ad hoc basis prior to 2007, only against sanctioned post, Lordship. So the respondents had already submitted the names to the Personal Department based on that format, Lordship. So there's a cabinet meeting, Lordship, 15 March 2022. Personal Department placed all those records before the cabinet meeting, and the cabinet meeting had regularized my service, Your Lordship.
Where's your names in that list?
In my writ petition, Your
That
Lordship.
in our affidavit notification also.
In the writ petition, Your
That is
Lordship.
subjected to 4 conditions, my Lord.
Let
They
us
should
see,
be
let us
working
see,
as
one second.
sanctioned posts, and they are not.
The affidavit by state is upon compliance on 11. What's the order date? 1110?
My name is included in page 61, Lordship.
Page?
61.
Of the affidavit?
Of the writ petition, Lordship.
Yeah, number 82 to 86.
83 and 84, Lordship.
Okay,
83 and 84. For item number 40, Lordship. Item 40 also same.
Which item number?
Number 40 also similar matter.
Okay, doesn't matter. But your names are here. Anyway, what did he say in the affidavit?
Yes, he stated that I'm working in a post on someone who has already expired and retired from
Lapse
service
post,
in a
Lordship.
lapse post, Lordship. Since the year 2001, Lordship, I have been working for more than 21 years, Lordship. There's no break of service in between, Lordship.
Oh, appointed against work charge post. Then you have to accommodate them somewhere else. Mistake been committed by you.
My Lord, mistake has been committed by, my Lord, if my humble submission by the officer, my Lord, who is in close relation with the petitioner. She has been passing all the orders in her own office, my Lord, without informing the
Have
government.
you taken action against her?
My Lord, at this point of time, I'm not in the position to say that. But
Then?
then, my Lord, she has passed this order against the order of the government also, my Lord, which we have mentioned in our affidavit also. She has been contradicting her own order, my Lord. In one hand, she says that
Where
they
is
are
that in the affidavit?
My Lord, in the additional affidavit, my Lord, we have pointed those
Yes.
those points, my Lord. And they were retained, my Lord, from time to time. They were not permanently appointed.
No, that is a general thing. That if the work charge establishment, if once the person dies, the post dies with a person who's been, working, then work charge establishment.
My Lord, in the additional affidavit, we have pointed out that the last person who should be working in this last post should be 2011. However, my Lord, after 2011 also, these people were illegally retained by the concerned office, my Lord.
Then,
So
who
therefore,
will
my
be
Lord,
responsible for that?
So, my Lord, apparently, Lord, at this point of time, my Lord, in 2022, their name has been recommended to the cabinet, and they have to undergo those interviews, my Lord, unless they satisfy those 4 criteria. Hopefully, my Lord, they will be absorbed. Otherwise, my Lord, if they don't fulfill.
You're out of service now.
My Lord,
Lordship,
yes.
I'm still in service, Lordship.
No, my Lord, they are not.
They are still asking me to come and work.
My Lord, they are going to
They
the
don't pay,
office,
Lordship.
requesting them to retain them, my Lord. They go to the officer every day, my Lord, requesting them. But that is not something that they're working.
Your Lordship, for the co-petitioner, Your Lordship, they asked me to come and work, but do not sign anything. For the other petitioner, for the time being, the work handled by me,
shall be handled by the junior engineer, Your Lordship. Till
No,
yet
I
I am still
understand.
working,
No,
Your
the only
Lordship.
thing is that, you see, this case is different from other cases because whatever, but how can that statement be made that's a work of mischief of one officer that resulted in giving them employment?
My lord, because the very first order of 2005, my lord, when they came into the picture, my lord, they also...
Are you recovering the monies paid to them
My
from
lord, that
from
we have
from
already
pension?
spoken to department. My lord, department will
They
take their
won't do
own call,
anything.
my lord. Department will take their own call.
Because this case is outside the bounds of law. This is different. The thing is that now these people have been working against labs, suppose, which is
My lord,
correct.
9 of
The
them
worksite
has...
establishment labs.
So, my lord, considering, my lord, on a humanitarian ground, 9 of them has already been offered contractual appointment, which they have accepted. Only
You
2,
take
my lord,
contractual appointment, then
they
it's not
refuse to accept, my lord.
Your Lordship,
They
I'll have to
refuse it.
take instructions from the...
You take contractual appointment, then you take it subject
My
to
lord,
outcome
my
of
lord,
petition.
My lord, 9 has already accepted. Only the
An
petitioner
affidavit has
refused to
been
accept
filed
it.
by the state respondents indicating that the petitioners herein were appointed against work charge establishment post which has since lapsed. So the reason given in the affidavit is that the said appointments were accorded by an officer of the department without any authority, and as such the same sought to be corrected by discontinuing the engagement of the petitioners as section assistants. Section assistants. Right?
Yes.
Stop. Next paragraph. MSR Colney, however, has submitted that, noting this fact, the state respondents have offered employment on contractual basis to the petitioners who are yet, although to such situated persons, who those who have accepted the petitioners have not accepted as yet.
Not accepted as yet.
Mr. Eman Nongpur, correct?
LG.
LG Nongpur, at this stage, please aim it out to obtain instructions with regard to the offer made by the state respondents with certifications. Otherwise,
My
difficult.
lord, one small thing, my lord. This particular division, my lord, do not even have section assistant posts, my lord.
No, that's besides the
that
point.
is one thing also, my lord. There's
That is more fantastic.
So that
I mean,
officer has actually been
this officer
appointing
should
them,
be
my
given a
lord.
gold medal then.
Well,
He
the
appointed
officer-
people to posts that don't exist, and that also to
That is
a
what,
division
my lord,
doesn't have
that
section
is what we have
assistants.
been trying to point out, that it is the close relative of the petitioner
Yes,
who
so
has
she's
been
upon a
appointing
chief
her
engineer also
without their more
to a
posts, my lord.
non-existent division. Yes.
41.
Yes. Yes. Is that mining matter?
Yes, Your Lordship.
Yes, Your Lord.
It is
Notifications
100.
are the request of Mr. Elam Sangma for the petitioner. On request of the parties, not Elam Sangma. That's what
42.
we'll take it up after vacations. Because from tomorrow also this court's not here. Yes.
Much obliged.
Obliged.
Please, Your Lordship, there is no urgency in this matter, so I pray after vacation.
Parties pay the matter under vacations, list accordingly. Also.
Same prayer for item 43 also.
45.
Come out of vacation.
You filed rejoinder? A rejoinder affidavit has been filed by the petitioner. This is a matter for hearing after vacation.
46.
May it please Your Lordship. Your Lordship, as per order dated 20/11/23, I am supposed to file my affidavit, Your Lordship. I will be filing the same in the course of the day.
Why it's come for hearing then?
Your Lordship, this is an additional affidavit that has been directed to be
MSN
filed.
Inokuri submits that the additional affidavit is allowed by this court by order dated 20/11/23. We filed the court already. And this is
I
a
have
matter of
received it.
vacations. Yes?
I have
You
received
received copy.
Give some time. Well, after vacation.
After vacation, yes.
Obliged, Your Lordship.
Alud.